Are you ready?
It's online.
We'll call the meeting to order. First on the agenda is the approval of minutes.
I move to approve the minutes from, I think, May 22nd and June 8th.
Is there a second?
I'll second. This is Susan.
Okay. Set been moved and seconded. Is there any discussion?
No.
Seeing as,
I would.
Correct.
what's that?
They would abstain from voting.
I would expect.
Yeah.
So
If they didn't know.
Commissioner Williams,
Aye.
Commissioner Altman,
Aye.
the chair votes aye. Second on the agenda, we have public comment, but before we get into that, I'd like to recognize the fact that we have two new commissioners here. And I think it would probably be appropriate for all of the commissioners to introduce themselves and tell just a little bit about who you are and where you represent, and a little about your background.
All right.
So, Commissioner Trowbridge.
I'm Patrick Trowbridge. I have lived in Bend and Deschutes County for 23 years. And I'm a real estate broker and a licensed general contractor, as well as I own a few properties, a couple commercial properties and residential properties here in Central Oregon. And have a family, raised 3 kids here, and plan on sticking around for the long haul. So yeah. Thanks
Commissioner
for
Williams?
having me.
And you are an at-large commissioner, is that correct?
Yes, I'm at large.
Tony Williams, I represent the South County. I too have been here for over 23 years. Own a window cleaning business, a concrete pumping business, a bookkeeping business, and like to be involved with the community.
Well, thank you. Commissioner Kelly.
Thanks for having me. My name is Kelsey Kelly. I was born and raised here in Bend. I went to Tumalo Elementary. That's the district I represent. And then graduated from Redmond High School. I'm a realtor as well. My office is Kelly Realty, and it's a little family office. I'm the 4th generation to work there. I also have 2 young boys that we're raising here in town, and I'm excited to be here. So thank you for having me.
You're welcome. Commissioner Altman.
Hi, I'm Susan Altman. I'm sorry I couldn't be there tonight. I am on my first term. This is my 3rd year in the Planning Commission. I represent Bend. I'm east of Bend in unincorporated Deschutes County. And previously, I also served on the Soil and Water Conservation District for 4 years. And I'm kind of just a geek about land use planning. I find it really interesting and happy to serve the community.
Great, thank you. And my name is Matt Cyrus. I am a 6th generation Oregonian. Been involved in farming in the Cloverdale area. I actually represent the Sisters community. I farm. We have a small excavation company. We also, our family owns Aspen Lakes Golf Course, and have been involved with the land use process for a lot of years, and serve on the board of Oregonians in Action and also Deschutes County Farm Bureau, as well as, and been a volunteer firefighter for the last 40 some years. So that's a little about me, and I appreciate everybody sharing who they are. And with that, we'll move on to public comment. Do we have anybody from the public that would like to address anything that isn't on today's agenda? And nobody on Zoom? All right, we'll move on. Action items. Says Planning Commission training. Is that you, Peter?
That's going to start with me, Commissioner Cyrus. For the record, Peter Gutowski, Community Development Director. Tracy, are you able to elevate that PowerPoint? Okay, perfect. I have, I will, I have a PowerPoint presentation to share with the Planning Commission, more of an orientation in light of our two new commissioners. Just thought it was a good opportunity to provide some context for our Planning Commission. Stephanie Marshall is here, who will talk about public meetings law, and Will Groves is going to take a moment in as part of this presentation to just orient, refamiliarize the Planning Commission to how we handle the record for land use proceedings. But it was our pleasure. Will Groves, Stephanie attended, and we had Tim Berg this afternoon from 4 to 5. Just, I guess I would call it onboarding for Commissioners Trowbridge and Kelly. Gave them some materials to review, and just again trying to establish an auspicious start to being a planning commissioner. We welcome both of you and look forward to collaborating with the entire planning commission going forward. So again, much of this information, I think, for a majority of the planning commission is not new, but I just thought it was worthwhile to provide this overview. And we may have some people online or at some point who want to watch this PowerPoint. I think it's somewhat informative. Both our two new commissioners were presented with our work plan, and the planning commissioners are well aware of the CDD's mission statement. We are structured with 4 divisions: the building division, on-site wastewater, land use, and coordinated services, to really facilitate development opportunities in a coordinated fashion in one building. We rely significantly on technology, and we continue to push technology to maximize those resources for our constituents. So this is our mission statement. I'm not going to read it entirely, but both of our new commissioners are well familiar with CDD, and it's just something I wanted to lean into. Again, we are here to protect public health and safety. We're a one-stop shop, and as our two new commissioners were reminded, we're a fee-supported department, and the community development department has many partnerships. We have a lot of seats at the table on regional issues as it pertains to an assortment of issues. So as we coordinate with our cities and as they are preparing for growth and development, we have a role, and the Planning Commission can have a role in that as well. An overview of the department. All of you are well aware of the Community Development Department. We now have 58 employees. This is the Planning Commission is responsible for looking at legislative matters that pertain to land use policy. This division is managed by Will Groves, who's behind me. It's important, and of course, the Planning Commission serves as that role. Going back, just worth highlighting that 2 of our other divisions, the building division and on-site wastewater, those teams, their managers, they're administering state regulations as it pertains to the building code and the on-site wastewater rules. A reminder to everyone that Deschutes County is a fairly large county, 3,000 square miles, but the percentage of area that is under the county's jurisdiction is quite modest. It's anywhere between 18 to 20%. And so most of our land is under federal land management, but for the land that is subject to Deschutes County's regulations and the statewide planning program, this Planning Commission can get involved in a host of issues. I mentioned this bar chart, or showed this bar chart to our 2 new commissioners today. We're very fortunate, in addition to Commissioner Cyrus, who's been here, and his family's been here for so long. All of you have experienced the growth that we've been experiencing over the last several decades, and where it's projected to go in the future over the next 10, 20, 30, 40 years. Deschutes County is going to continue to be at the forefront of how to manage growth and development, maintain a vibrant community, address resiliency as it pertains to natural hazards and protect natural resources. So this bar chart just acknowledges that all of us are going to be involved in numerous discussions and processes that deal with growth and development now going forward. The population forecast, this is just another slide. This is coming from Portland State University's Population Research Center. And they update that every 4 to 6 years now, based on some changes to state law. So again, this is just letting another way of depicting growth that's going to be happening in the rural county as well as in our 4 respective cities. As it pertains to the Planning Commission, we have 7 members. We have our chair and vice chair are presently absent, but the Planning Commission is appointed by the board. It's our Citizen Involvement Committee under Goal 1. You're largely going to be addressing policy issues that pertain to the unincorporated area of Deschutes County. Our Planning Commission are volunteers, and we're greatly appreciative of that commitment to public service. You have tremendous powers and duties and authorities. You are here to receive public input from constituents and residents of Deschutes County. And that is going to, over the next several months, is going to get into community planning and transportation planning and our comprehensive plan. And you are really the first body that receives genuine public input through a public hearings process and ultimately making recommendations to the Board of County Commissioners. And as I mentioned, it's you're really carrying out as part of the statewide land use program, our citizen involvement arm for comprehensive planning. You do make recommendations ultimately to the Board of County Commissioners following typically public hearings. And the other thing that I alerted our 2 new planning commissioners is you implement the long range work program of Deschutes County. And there are a number of noteworthy projects that are on that work plan. And I wasn't kidding that in 12 months, you will be as seasoned as any planning commission in the state, just in terms of the variety of topics and the level of public interest and the recommendations that you will ultimately make to the board. Oops, I'm sorry, I went too fast. Here we go here. Okay, this slide just captures our planning commission structure, which is noted in county code. Planning commissioners serve 4-year terms, and you can serve 2 4-year terms, or if you were to absorb an active term, it can be up to a total of 10 years. We're fortunate to have planning commissioners representing most of the geographic areas from Deschutes County, as Commissioner Cyrus just acknowledged through the introductions that we had today. In terms of outboarding, I put this slide together because I wanted Commissioner Williams and Altman and Cyrus to know that we provided our new colleagues with the policy and procedures manual, the work plan. I was grateful that Tim Berg was available, one of our systems analysts, to talk about our DIAL, our geographic information system, provided information about just ethics as it comes with being a planning commissioner, roles and responsibilities as a planning commissioner, and what you can expect in terms of your engagement with staff. So it was a lot of material. We didn't go through it extensively, but I think these materials are very useful to put our colleagues in a position to be active participants in forthcoming public processes that literally start next month with the transportation system plan and the Tumalo community plan. So bear with me. This is the planning program. I want to just quickly, this is kind of the foundation of what makes Oregon so distinctive. Oregon has a statewide land use program stemming from Senate Bill 100, which was state enabling legislation that started in 1973. There are 14 of those 19 statewide planning goals apply to Deschutes County. And our comprehensive plan and corresponding implementation ordinances implement the statewide planning program. There's some foundational pieces that I think are always worth highlighting. Back in 1926, constitutional law, the Supreme Court recognized that localities have under their police power the ability to regulate land use. And it was very validating as we try to integrate our team in community development department. We have different divisions I was talking about, and we had two of our newer planners who have been with us maybe two years at most. We're giving a presentation to their colleagues, permit technicians, on-site wastewater specialists, who are all, some of them also new to this, to Deschutes County. Gave them an overview about land use, and so they talked about the origins of planning. So I got off on a side note, but I was grateful that we're cross-training and providing context for, in this case, why we have so many land use planners and what their responsibilities are and what the historical context is. As I mentioned, Senate Bill 100 was the foundation of the Oregon land use system. It does a lot of things really well, or some might say does things overly restrictively, but it does emphasize protecting farm and forest land. It emphasizes citizen involvement, and you are such an important part of that as the citizen involvement arm for Deschutes County. And as I mentioned to our two new commissioners, over time we're going to get out into the community. We're going to have some retreats and really make the commission available to our residents as topics come up. I mean, just in the spring, we had staff and there were members of the Planning Commission in Sisters. We were in Redmond talking about mule deer wildlife inventory updates. So we are very open to get out into the community at locations and at times that are presumably available to a number of constituents. So we really pride ourselves on that accommodation and accessibility. The Senate Bill 100 does a lot of other things. I'm not going to read the bullets specifically, but it does leverage the importance of comprehensive plan. It created a statewide land use commission and a appeals process, starting with the Land Use Board of Appeals. This one case, Fasano versus the Board of County Commissioners of Washington County, this really validated the role of comprehensive planning in Oregon. It requires that any implementing ordinances like zoning be consistent with the comprehensive plan. So Oregon's unique for many different reasons. Land use is certainly one of those, and it's based on a comprehensive planning framework that again extends back to those 19 statewide planning goals. A little bit of fun fact, history: Deschutes County's first comprehensive plan was adopted in the early 70s. Its first attempt at a comprehensive plan was rejected by the voters in the late 60s. But ultimately, we first came into compliance with the program back in 1979. We've gone through a series of updates over the last several decades. And one of the things that we're really grateful for is the Board of County Commissioners recognizes the role of making sure that the comprehensive plan is up to date. So later this fall, the Planning Commission will host public hearings, likely more than one, to hear from residents about their perspectives regarding how Deschutes County can guide, and accommodate growth and development now and into the future, especially when you look at those population projections. Here's some of the history. I mentioned I said the comprehensive plan. It was the zoning ordinance that was attempted to be adopted in the 60s. It was repealed by voters in 1968. But you can see that there's been a continuing effort to update the comprehensive plan. Into the 80s, into the 90s, into the 2000s, and we're going to be on our way to have a comprehensive plan that addresses growth and development out to 2040. Just some context again, and I know that for many of you, this is somewhat redundant, but it just seems important from a training standpoint. Again, to the extent anybody's listening online or finds themselves listening online, but we have a current planning division or current planning section that implements the comprehensive plan through zoning on a daily basis. We tend to have anywhere between 800 to 1,000 land use applications a year. A small subset of those are ultimately appealed to the Land Use Board of Appeals, not because of any reckless decision that Deschutes County executed. It just comes down to the fact that land use is complicated. It's in Deschutes County. It can be a bit of a contact sport now for certain topics. And because the program is premised on citizen involvement, the ability to have standing and to engage in a land use proceeding, even if one wants to go and challenge a decision, starting with the Land Use Board of Appeals, the entry level is relatively modest. And so as we grow and as development is seen, not necessarily always in the most compatible light, for those that feel strongly, they can object to local land use decisions. They can appeal it through the local process and ultimately get it into the courts. Current planning, it's also, again, as we think about this one-stop shop, this coordinated department that we have, our planners are also making sure that land use is in alignment with building permits and with on-site wastewater requirements. So again, long-range planning, this is the team that you're going to be interacting with as I look at our new commissioners regularly. They're developing policy and refining regulations through our comprehensive plan, through our area plans, county code, and quite often there are special projects. This planning commission will convene if they feel compelled to, and we've had a commissioner sit on this side in water panel discussions or panels about marijuana or hemp or any number of topics. So as a commission, you have the ability, if you feel like there's a topic that galvanized the community on a particular set of amendments or policy conversations, what's done in the past is that respectful request, can we get a panel together? Can we continue this conversation to further understand, for example, water policy? It's been helpful. I think it provides a community service. Those meetings are recorded, and quite often it's a very informative 60 minutes, 60, 90 minutes when you hear colleagues at the local, state, and federal level sharing their perspectives about that specific subject matter. We do coordinate we have a statutory requirement to coordinate with our cities. When cities expand their urban growth boundary amendments legislatively, this planning commission will be one of the first to convene a public hearing to take testimony on those growth management plans. That happens infrequently. Long-range planning also has responsibilities. Just for context, every year we fill out questionnaires that inform population estimates and ultimately population forecasting. We are tracking legislation in the regular session. We'll talk about some of those. And certainly Kyle's piece, the next agenda item is stemming straight from 2023 legislation. Many of our staff serve on committees, so we do everything we can to understand the regional conversations that are happening in our community, and do everything we can to inform the planning commission on those circumstances as new information is being shared. We want to share it with you as we do with the Board of County Commissioners. Okay, this is my plug for Will. I think this is going to be helpful for us. It's a good reminder. Yes, please.
One quick question from the jurisdiction page, and I had actually printed it up because I did want clarification. The county has jurisdiction over 18% approximately. Would that be like the white areas of the map? And then
for the most part, I think that's true.
And then there's like state and county ownership percentages. And is it just because it's such a small percentage that we didn't break the state and the county out.
Right, when you look at public ownership, so
Mhm.
that map's been used a number of different ways. Sometimes conversations will come up, how much land in Deschutes County is managed or owned by government entities? And when you factor in local governments, state governments, and the federal, it gets to be close to 80%. 80% of Deschutes County is under government ownership or control.
So, but basically, we make recommendations on the white portion only,
I think that is correct. There are areas. and-
approximately like page 7.
Yeah, I can, I don't have the ability, I do have the ability to go back up.
Actually, follow up on that. Does
Please.
our jurisdiction cover the county owned ground?
Does our jurisdiction cover the county owned?
Yes.
Yes, it does.
Okay, so the county owned actually probably should be into the white as jurisdiction because we don't have jurisdiction over the state or federal.
We do have jurisdiction over the state.
Oh, we do on the state. Okay.
So this map is so old, but I would agree with Commissioner Williams' summation that the areas in white reflect the area that is subject to Deschutes County's jurisdiction. So that would,
And what we make recommendations on then.
as it pertains to
As
policy
a-
issues that affect
planning.
those white areas.
Okay.
Correct. That's right. That's right.
Thank you.
Thank you.
So I will turn it over to Will. You can, if you want to disengage, Tracy, the PowerPoint that I was using, and I think does that give you the ability, Will, to show your laptop?
So I've set up my screen sharing here. Let's see if we can get that switched over.
This is second here as we're juggling technology.
Okay. Yeah, she told us about.
Oh, I didn't know.
In readdress.
She just said this is her first time
Yeah.
alone.
With you guys here.
I've read most of it. Without getting cross-eyed.
So that's our next one on the agenda is to go through this line by line.
Okay, there you go. You're in.
There we go.
Thank you.
Hey, thanks, Commissioner. For Planning Manager Groves here to talk to you a little bit about the resources that you have to see online what's going on. We have created a Deschutes County Engagement Center. So this is where we have a hub for all the things that are going on with, in particular with planning. And I just Googled Deschutes County Engage when I want to get here. There is in fact, it's www.deschutes.org/CD/page /community-engagement-center. That suggests just Googling that. And what we've got on that page, as you can see, is a variety of projects. We've got some general descriptions of what's going on. We've got some prominent projects here. But for your purposes, the main thing you'll be doing here is looking over in the left bar here to land use hearings on the left side of the screen. And by opening that up, you can see planning commission hearings. And in this case, you can see those hearings that are either upcoming or currently going on. If you click on one of those, it'll take you to a web page that is specific to that proposal. So there'll be the file number, a short summary of the proposal, the status of the proposal, contact for the staff planner. So if you've got any questions for the staff planner, you can either email or call. And as you scroll on down, let's see, let me find one that's got some. I'm going to hop over to the mule deer inventory because that has some testimony associated with it. So again, this is the mule deer inventory that had been discontinued by the board, but it's a proposal summary, some background, project status, some things about the code, some maps. And then down here, you'll see this section here that has the variety of testimony that we received. So if you want to take a look at agency submittals, if agencies submit things to us in writing or via email, we then upload this to this website and they're available as PDFs. So one of the things you'll be doing to the extent that you're engaging with hearing materials is you may want to look at the public comments or other materials have been available. So you can click on any of these, it'll open it up as a PDF. And then you can see there's subsections of that. So there were public comments that were received. There's decisions and memos and orders and staff reports. Some of the notices that we sent out, public comments before the board that were that hearing didn't occur, but were received for that. Other miscellaneous documents. So you're looking for the resource where to look at materials that are before you in the event that you're having a public hearing on a day or are coming into deliberations and want to review those materials that have been provided. This is your best resource for that. And these things are generally updated within about 24 to 48 hours of us receiving them. We push them faster, obviously, when there's a matter that's about to be before you. But this is to the extent you want to see what's in the record and what people put before you for the purpose of the decision. This is what's there. It's also important to remember that when you make decisions or you make recommendations, it's important to remember that you need to do that against the record. So let's say that you had independently, you said, hey, you know, somebody handed me this aerial photo and it's caused me to think about this whole thing quite differently. That can be problematic because that's then not something available to the public. It's not something that someone could rebut. It's not something that everyone else gets to see. So to the extent that you have a piece of evidence that you believe that should be before yourself and the planning commission, it's important that you submit that to staff, and then we can put that in here. You are allowed to submit materials to that record, and it gives an opportunity for everybody to take a look at it. It's important that you don't make a decision based on evidence that you've taken outside of the record as you run through this. And we'll talk a little bit more about that likely later, but just a reminder to give us something if you think it's important. We're certainly, the purpose of the record is to collect all the relevant documents we can and give you a good opportunity to take a look at what's there, and particularly the public engagement can be very helpful. Do you have any questions about this engagement center, getting to the materials, navigating it?
And I really appreciate Will just offering that overview for our seasoned planning commissioners. You're aware that the memorandums that you're getting or the staff reports you're getting from staff are giving you a link that are taking you to a designated website to allow you to review the testimony or any, you know, giving you the context of the project that's being before you. I thought this would be really helpful for our two new commissioners. We talked a little bit about today as well with Tim Berg, but we are trying to do everything we can to make to provide information about policy or text amendments that are before the planning commission, get that, put it in a format that's accessible for the public and certainly accessible for the planning commission. So there was it wasn't too long ago where Kyle would come up and he'd say, I want to introduce the case file in the record, and it'd be a big, sound on the desk as multiple files were set. This is the record, and everything would be just paper oriented. You would get, if you thought today's packet was large, I mean, the packets could get quite voluminous. So we're trying to manage that in a way by sending you to the website. So I thank you for offering that.
And I don't have a question, but I would encourage our new commissioners to utilize that site. And even if you've checked in on a Monday and the meeting is Thursday, you'd be amazed at the volumes of either agency input or public input that can come in a matter of days.
Yeah, I was unaware of that one, so I appreciate that.
Tracy, you don't need to put the PowerPoint back up. I just have some closing remarks for this portion of the training, and then I want to allow Stephanie to just provide some context for public meetings law. But I as I mentioned in kind of some of the themes as this planning commission looks forward, it's exciting. The comprehensive plan update is going to raise a number of themes about how do we manage population growth? How do we maintain a resilient and vibrant community? How do we manage our natural resources, improve our transportation system? And one of the things that all of us, everyone, including Stephanie, experience every day is the partnerships, and all of you experience every day in what you do in your careers. But the partnerships and the collaboration that occur in this county, I think, is remarkable, and it's one of the reasons why I think we're so attractive for families, for businesses, for visitors, is because of the relationships that span both public and private sectors. And this planning commission, you're a huge part of that. So that was kind of the training 101 to our two new commissioners. You can, let me know, at a later time if you felt that this was effective. But I wanted to share this overview to all of our existing seasoned commissioners, because I thought it would be worthwhile, again, just to put it back into context of why are we here, and why this commission is so important for Deschutes County. So Stephanie, I'll pivot and transition to you. Thank you for being here.
Great. Absolutely. Good evening, everyone. Stephanie Marshall, Assistant Legal Counsel here at Deschutes County. I don't have a PowerPoint, but I did want to do a very quick introduction. I've been practicing law since 1994, did the first 12 years up in Seattle, then moved to Bend in 2006. Raised my 4 children. They're all grown, not all gone. But, it's a wonderful place, and I'm just so grateful for all the opportunities that my children and myself have had over the years. I joined the county last year in August 1st of last year, after doing some service as a hearings officer. Hearings officers are not employees of the county through an independent contract, but my entire career, really since 1994, has been land use and real estate law. And I'm versed in both Oregon and Washington state systems. Peter and Will, thank you so much. You've really laid the groundwork so well. And really, what can I add to that is just, over the last 6 months, and, I'm kind of seeing a trend, there's a lot of really engaged people in our community, and it's really exciting, and at times can be challenging. And this is the beauty of having a planning commission, a board of commissioners, planning commissioners, not a board, to take that first step, to take in a lot of the information, to take in testimony, and then ultimately make that recommendation to the Board of County Commissioners. Although you're not elected officials, you have a very important role in maintaining this integrity of the county in general, but really with respect to the items that the Community Development Department has on its plate, whether they're applicant initiated or staff initiated or direction from the board to follow through on things like accessory dwelling units. Really, as far as open public meetings law, conflicts of interest, that my best piece of advice is if you have any doubt, it might be, worth disclosing, first of all, at a meeting, or feel free to pick up the phone and contact either myself directly or Peter. We can talk through, what might be a concern. One of the planning commissioners has very aptly noted that, there's a lot of things that come before the planning commission that, affect so many people across the entire county. Maybe say mule deer. A lot of people would have been affected by that. That's currently on pause, and we'll see if it comes back to the board in the future. But it can sometimes be difficult to determine if there's an actual conflict of interest. So that's where I encourage you to reach out and see if it's something you need to disclose. And then the next question to ask yourself before you disclose in a hearing or in a meeting is, I have some, I could be affected by this in this way. That being said, I believe I can put my personal, maybe this will help me or hurt me aside, and I can listen to what's before me in this record from the people that are here. Now, if you don't think you can, that doesn't mean you've done anything wrong. It just means you might want to consider recusing yourself. There are, like I said, there are so many issues that might tangentially affect you. If you have any questions, again, reach out to us, err on the side of disclosure, and, and then ask yourself the question as to whether you think you can, just kind of put what you bring to the Planning Commission aside to consider the evidence before you. Some people can do that and not others. And it depends on what the issue might be. Again, does not mean you've done anything wrong. Does not mean that you're not meeting your responsibilities as a planning commissioner. In fact, I'd say just the opposite. We want to maintain the appearance of transparency to our citizens and, just kind of putting it all on the table. And you are interested, you're up there as a representative of the county, and people are taking, there's some distrust of government, and there's some concerns about government overreach. And so anything you can do to maybe not add to that, again, that's kind of amorphous, but kind of just wanted to note that in general. Everything that Peter touched on with the, kind of foundation of zoning law, the only thing that I'll add to that is when we're enacting, or when the county is enacting land use regulations or amending its comprehensive plan, these are to protect the public health, safety, and welfare. So that's kind of the authority that's being exercised when it gets to the board. Whatever they choose to do has to be, there has to be some touch to something that we're doing to help the public health, safety, and welfare. So that's where police power, AKA zoning power, comes from. And over the years, for those of you who want to, legal 101, there can be conflicts between what some people think really this is where the government needs to be doing to protect this interest or that interest, this public health issue or this safety issue can sometimes run crossways with people's right to do, or their belief that they can do whatever they want with their property. So that's, I could spend an hour or two just talking about takings law and rough proportionality and nexus and inverse condemnation. I'm not going to be able to go over all of that. But and Peter had mentioned when he asked me to present here to touch on measures 49 and 50. So that's kind of that intersection. The county can adopt new regulations to the extent that it affects somebody's, like the range of uses, and it devalues their property. They have 5 years from the date that a new regulation is adopted to follow the Oregon statute, and they have to get an appraisal, and they have to show, like specifically, it can't just be, if you put that, rehab center down the street, I can't, it's going to plummet, it's got to be more than that. But these laws have gone into place to allow some flexibility on both sides. And what the county can do when they get a Measure 49 claim is to decide whether they're going to waive that regulation because it's impacting property value, or whether they're going to pay just compensation. And again, that's very highest level of how takings law and private property rights intersect with police power authority, and the various, so many competing interests and I mean, it's tough, you know, I mean, if the new commissioners watched anything with the mule deer, you know, I mean, there's a lot of strong opinions on not only what is happening on the ground, but what can we do and what should we do and how should we exercise the police power. So it's, you can learn a lot, you know, that's why I, you know, been doing land use law for decades. But it is very, very interesting. And, you know, you might hear about a Measure 56 notice, which is the notice that goes out to potentially affected property owners, just to alert them that there might be a regulation that could be adopted that might impact the uses of their property and could change the value. So again, I could have presented a PowerPoint. I could have talked for 45 minutes to an hour and a half on land use, case law at the federal and state level, intersection with, you know, the statewide planning goals. Peter and Will did such a great job that I just kind of thought I'd put a little bit of icing on the cake and leave it there. But, you know, I just want to close with, you know, we're a resource, you know, everybody over at CDD, county legal, please reach out if you've got questions, and if there are concerns, and there's no bad questions. So feel free to pick up the phone at any time. And if you have any questions for me, let me
Any
know.
questions?
No questions.
I have one.
Yeah.
So would be safe to say that issues that require or the county sends out a Measure 56 notice is likely, or an issue that likely to involve Measure 49 implications?
Yes.
In essence, there's no reason to send out Measure 56 notices unless there's Measure 49 implications.
That's maybe too simplified, but you know, anything that's going to change the uses. And again, you know, I mean, I would say that it's a bit of a heavy burden for a property owner to make a successful Measure 49 claim. It's certainly not impossible. We've seen many of them over the years, but yeah, I mean, definitely, you know, the county will err on the side of let's make sure that we put out notice. It doesn't mean like, okay, well, once this regulation is adopted, any of y'all can submit 49 claims.
Right. But I guess my point is
Yeah.
there is a nexus between the two that
Yeah.
in essence, there's no Measure 56 unless there's a possibility of a Measure 49.
I would say that's pretty fair.
Yeah, I mean, I think what I would say, Commissioner Cyrus, for further context is my dates may be off a bit, but in 1998, the voters of Oregon approved an initiative, a ballot initiative that respectfully requested this, a notice of this type when government, local government and state are preparing land use regulations that could impact a property and the value of that property. There's specific language in statute based on this initiative that local governments have to use. Doesn't mean that all regulation, even some regulations that limit, automatically lead to a reduction in property value. And so we have done over the years, you know, you would see like we would send out a mailer to that effect, and sometimes a pamphlet that would contain that statutory language, and then the rest of the pamphlet would be like, this is what we're doing. So for example, one that comes to mind is over 10 years ago, per the direction of the Board of County Commissioners, we amended the destination resort map. Long story. The map was established in 1992 through Eagle Crest. They wanted to expand. It was a historic resort. They wanted to expand under the Goal 8 statutes for destination resorts. 20 years later, there was the legislature provided opportunities to amend a map outside of what's called periodic review, of this extensive state coordination effort for updating a comprehensive plan. in the way that the Eagle, sorry, this is just puts this into context. So Eagle Crest, the way Eagle Crest led the effort for the mapping, there were tens of thousands of acres of land that were mapped based on this criteria that Eagle Crest used that were so small, there would never be a destination resort. To be a destination resort, you have to have a minimum of 160 acres. But the way that Eagle Crest mapped it back in in the county ultimately is if you met the criteria, if you met the criteria, you were automatically in. There wasn't this kind of area analysis. So what the county did in coordination with the board and the planning commission is we alerted property owners of the ability to take themselves off the map. It was voluntary. We knew that there was a strong affiliation to a mapping designation, but because we wanted to have the most accurate destination resort map possible, we did a Measure 56 notice. And there was a process where affected property owners could, and many did. They're like, I'm never going to be a destination resort. I don't want to be next to a destination resort. So that's an example of a Measure 56 notice that would not have led to a Measure 49 circumstance because of the way the county structured the program. But to Commissioner Cyrus's point, there can be some correlation. It just depends on the issue, which lands it's affecting. As I recall, Measure 49 comes into play if a local government is thinking about adding restrictive or tightening regulations on housing or regulations that affect farm use. If you're regulating different other zoning categories, my understanding, as I look to my attorney, I don't know if Measure 49 comes into play. So it's complicated, but we are I think a fairly sophisticated county. And so we're well aware of when Measure 56 notice has to occur. And we are certainly aware when, if per directed by the board, if we're trying to tighten regulations or clarify regulations in a way that could impact property, that there could be a potential for a Measure 49 claim. We have not received a Measure 49 claim. There was a retroactive aspect of Measure 49 when it was affiliated with Measure 37. But to my knowledge, we have not had a Measure 49 claim for regulations that were proposed and ultimately adopted after, I want to say 2003.
Yeah, that sounds right to me.
So anyway, it's a lot to unpack, but our commission wanted to get some context about Measure 49 and Measure 56. It's both of these are obligations that require local and state governments to be aware of. There are times when the state government is compelled to make regulations per the legislature or per responsibilities as dictated by Land Conservation and Development Commission. If the state changes land use regulations that could impact private property, that could potentially devalue, the state reimburses localities to amend their codes to be in alignment. So there's a lot of coordination that can.
Yes, and I'm glad you touched on that too.
Yeah. So more to come, but was that helpful?
Yeah, thank you.
Well, thank you. We've been at it for just about an hour, but
So is that everything you've got with regard to the training then?
that concludes the training that Stephanie, myself, Will wanted to provide. We are certainly open to your question or comments, but it was done in a way to hopefully we haven't overwhelmed our two new commissioners to onboard them in a way that gets them ready for some of the items coming this summer and into the fall.
So anybody have any questions for any of the presenters?
No. Thank you.
Great, thank you. The next item on the agenda is the text amendment work session for rural accessory dwellings.
Good evening, commissioners. For the record, Kyle Collins, Associate Planner. If you give me a second, I'm going to cue some stuff up here. I've got a presentation for you. Right. There we go. So as Commissioner Cyrus pointed out, this is a work session regarding some proposed rural accessory dwelling unit text amendments. We've been directed by the Board of County Commissioners to put together a legislative package that would allow rural ADUs in certain areas of the county pursuant to some state legislation that passed back in 2021. This is actually a somewhat strange occurrence here because the Planning Commission has actually already seen a version of these amendments back in last fall and made some recommendations to the board. However, in the interim, there's been some state legislation that passed that changed the overarching rules at the state level that governs any of these programs that might be adopted by counties. And so we've had to make some amendments, and per board direction, we're bringing these new amendments back before the commission so they can review the previous recommendations and determine if they want to make any edits, changes, modifications before the Board of County Commissioners ultimately hosts a public hearing on this matter. So I'm going to go through some of the process updates just to bring everyone up to speed. I apologize in advance. This will be relatively dense because we got a lot of information to go through relatively quickly. But if you have questions as I'm going through any of this, feel free to stop me. So as I stated, some of the previous actions, the commission oversaw a version of these amendments back in September of last year. And ultimately, they provided recommendations based on that package to the board in October of last year. Since those last actions by the commission, a new piece of state legislation, Senate Bill 644, was passed. And as I stated earlier, it requires several changes to our original proposed amendments to maintain compliance with the new state standards. We've also made some additional edits to maintain clear and objective standards and to address some feedback from other agencies and departments. This is specifically related to some recent case law that required clear and objective standards for new types of residential legislation that might be passed. Generally, you can think of this as an attempt by constituents to have local governments adopt rules that any person off of the street could apply when it relates to residential development. So we're removing discretion where possible to have clear and objective standards, although local governments are allowed to have supplementary discretionary standards where they feel appropriate. And I'll explain that a little bit more as we go through some of these new edits. So based on that new legislation, the board directed staff to provide the commission here an opportunity to re-review the revised amendments and, as I stated, provide any new or modified recommendations that they might want. Of course, we also have two new planning commissioners here who are fresh to this subject. And so while a lot of this will be retreading old ground for the older commissioners, the two new ones, this is sort of the whirlwind tour of everything that's been proposed thus far. So that's just the general process updates. And now I'll go through some of the background to explain how we got to where we are today. So the proposal, it's a county initiated proposal to allow formal provisions for rural accessory dwelling units as identified in Senate Bills 391 and 644. I've already explained a little bit about Senate Bill 644, but Senate Bill 391 was the original state legislation that allowed counties to adopt rural ADU provisions. It passed in June of 2021. And some of the big overview pieces of Senate Bill 391, it's a permissive bill, so it doesn't require counties to adopt rural ADU legislation at all. We've been directed by the board, obviously, to propose a suite of amendments, which you're reviewing today. It also doesn't prohibit counties from imposing any additional restrictions that are not specifically identified within Senate Bill 391. Things related to, let's say, outbuildings, garages, how you might deal with those in conjunction with a proposed ADU. And then finally, the legislation applies only to unincorporated rural residential exception areas. So in Deschutes County, that excludes all of our 4 incorporated cities, Bend, Redmond, Sisters, and Lapine. It also excludes our resource zoned lands, so farm and forest zone lands. Senate Bill 644, I gave a brief overview of this a second ago, but it was passed in May of this year, and it alters some previous language of Senate Bill 391, specifically regarding recently passed state wildfire mitigation efforts. In a nutshell, it decouples the requirement that the state wildfire, what is now called the state wildfire hazard map, from the adoption of any local rules allowing rural ADUs. So the previous language of Senate Bill 391 specifically required that this statewide map that will ultimately be released by the Oregon Department of Forestry had to be adopted and in place before any local jurisdiction could actually implement a rural ADU program. With the passage of Senate Bill 644, that's no longer the case, and there are some new interim rules regarding wildfire mitigation for rural ADUs, which we've placed into these new draft amendments. So there's some local interpretations specifically related to both of these bill that were not identified with clear standards by each of them, and we've had to make some interpretive decisions and decision points for yourselves as the commission to review. Here's a list of all the code sections that would be affected by the proposed amendments. I'm not going to go through these in detail, but if you'd like to look through them, you're welcome to see what each of these are. Almost all of them are just related to the individual zones where rural ADUs would be allowed. 2 of the sections identify the actual specifics of how this program could be implemented. So some of the basic eligibility criteria from each of the Senate bills. As I stated earlier, these apply specifically to rural residential exception areas. In Deschutes County, that applies to 5 zoning districts: the rural residential 10 or RR10 zone, the multiple use agricultural or MUA 10 zone, the SR 2.5 or the suburban residential zone, the urban area reserve zone, and then finally the West Side Transect zone. So those are the only zones where a rural ADU program could actually be implemented pursuant to state law. Any property hoping to construct an ADU has to be at least 2 acres or larger. And then no portion of the lot can be within a designated area of critical state concern. We only have one of those in Deschutes County. It's the Metolius River Basin up in the northwest corner. Due to the zoning in that particular area, there actually aren't any properties that would be eligible in that particular area anyway.
Camp Sherman, that area.
Generally. So based on that basic eligibility criteria from each of the Senate bills, there are just shy of 9,500 properties in Deschutes County that could potentially qualify for an ADU. However, there's a big caveat to that, in that there are certain limitations at property specific or county levels that could pretty broadly affect that. One of the big ones that I've flagged here is our onsite wastewater division has specifically requested a 5-acre minimum standard rather than the 2-acre minimum standard in southern Deschutes County based on wastewater contamination and groundwater contamination concerns. And that would reduce the potential eligibility down to about 8,600 properties.
I have a question about that one.
Of course,
So, and I know that was Todd Cleveland, right, that weighed in on that.
himself as well as other parties. Yes.
Okay. So, and it can't be answered now. Obviously, he's not here, but it's in my experience, I've done some projects on properties in South County. I have a lot in Lapine right now that I just had a septic feasibility done on, and it just seems like it's been a pretty much a blanket. If you can get it to perk, it's pretty much going to be an ATT system, the alternative treatment systems, which take up a extremely small area for a leach field. It's a fraction of what a typical standard system is. So I'm just curious, and I know Todd and respect him. He's got a lot of knowledge. I'm just curious what would be the big difference of 5 acres versus 2 when you only need it's only a few thousand square feet for a system, and then a reserve, maybe even have a third reserve, and you'd still have a lot of ground. So I'm just curious how they arrived at that. All right, we're going to mark it up to 5 acres instead of 2, since I wasn't here.
Yeah. That's a great question. Ultimately, I would have to defer to Todd a little bit here. I am not the expert. I'm not a soil scientist, and I don't work in the on-site division. However, Todd's comments were specifically based on, I think, 2 big factors. One are rules from the Department of Environmental Quality at the state level that identify kind of a broad range of property sizes at which nitrate pollution into groundwater is reduced below a certain point. The second is based on a USGS study in southern Deschutes County that specifically identified groundwater pollution concerns in that entire basin that occurred back in 2007. And so that identified both an ongoing problem as well as the geographic area where those impacts were occurring. And then there's specific DEQ rules associated with trying to reduce and remove those contaminants over time. This 5-acre minimum is not a perfectly scientific proposal. It's basically a compromise piece of legislation to still allow some rural ADU development in southern Deschutes County while removing some of the groundwater contamination concerns.
So it's primarily their fear of nitrate loading and density.
Correct.
And so I guess maybe an alternative that we might consider is that we do a 5-acre minimum unless they can get through an exceptions process with DEQ, given specific criteria or soil conditions or whatever. Is that?
That's certainly something you could discuss and recommend. Ultimately, again, because I am not Todd and I am not an expertise in this area, I have to defer to him to how he might respond to that particular recommendation. And ultimately, Todd will be coming to the board during the upcoming public hearing process to actually discuss this matter in a more broad context. But good questions.
Okay. So
All right.
we'll have time to talk with the experts on that and go deeper into that at another meeting.
The board ultimately will, but you unfortunately will
Okay.
not. We're in a little bit of a compressed time frame.
Yeah, my understanding is they expect us to make recommendations on this tonight.
Correct.
Oh,
Yeah. This
So we can discuss the potential of conditions and criteria and exceptions when we get to that point in this discussion.
okay.
Yeah, ultimately, all of this will conclude with a set of, in front of you, you should all have kind of a recommendation matrix. Those are some big broad areas that I've identified as staff that you ultimately need to make recommendations on tonight, if you want to change them at all from the previous recommendations. And of course, you're welcome to add or discuss anything else that doesn't appear there.
Mr. Cyrus, could I offer just some follow-up?
Sure.
To just for further context on the question by Commissioner Trowbridge, as Kyle noted, my understanding, and again, it wasn't an absolute analysis or conclusive of the analysis of the USGS study, but there is a real concern and awareness of as Commissioner Cyrus said, of nitrate loading. And even with an ATT system, you're still providing an additional nitrate load into a sole source aquifer. For context for the variance, and I know you know this, Commissioner Trowbridge, but the variance proceedings are typically what has happened in the past in South County is Todd and his team will evaluate through an authorization permit the feasibility of a septic system. If they find that the conditions of the site, depth of groundwater, soil characteristics, location specific to other properties, other wells, they will recommend denial. And then the variance proceeding allows someone to appeal it to DEQ.
Yes.
There was just recently a case, it was somewhat unprecedented, where something like that happened. DEQ denied the variance and it went to circuit court. And Todd Cleveland was subpoenaed and then deposed. And just within the last couple of weeks, the circuit court judge found in the favor of DEQ in the denial of the variance. So I just offer that as, if you're looking for options around the 5-acre, there's some challenges with the variance proceeding because staff will have to get to a variance. Staff will, based on their best judgment and an understanding of the superficial geology and the water conditions, will have made a recommendation for denial. I'm not trying to.
No, that's part of the process of that variance. You
Right.
must first get a denial.
Exactly.
And then you go to the next.
Yeah, perfect. I just wanted to put that on just for clarity for everyone else. Yeah.
And then the other level of that ATT system, and that's what comes out of these variances, is you go not just an ATT, but you have an ATT attached to a sand mound filter. So it takes it to another level. And my question is, okay, what difference is it if it's 2 acres or 5 acres, other than limiting the amount of potential ADUs? That's what it seems like. It's not really a scientific soil recommendation. It's because of just to limit the potential having that many more ADUs.
Correct. I think it's exactly,
Yeah.
it's the additional density potentially in South Deschutes County, which is vulnerable to nitrate loading. And so it's that sensitivity. And just as Kyle noted, there's an acknowledgement that there are these opportunities, and for Todd and I think in his best educated judgment, what is that threshold to allow for some development while being mindful of the responsibility of trying to protect a sole source aquifer that is already contending with nitrate loading that's been happening for decades.
Yeah, I would suggest that maybe we address those specifics when we get to that portion of the deal. Commissioner Williams, you had a question?
Not a question, but if I could just
Comment. Sorry.
a personal perspective being in the South County. I lived in a manufactured home for nearly 20 years. We rebuilt on our property. The inspector came out and said that our concrete tank was in perfect shape. Nothing wrong with our concrete tank, but in order for us to rebuild, and we were not adding any more load at all, we had to go to an ATT. So, and we didn't, it was one apple here and one apple here, but this apple was, a lot more expensive.
Yeah.
So that's just a personal perspective about what's going on in the South County.
Yeah. Yep. I've done a lot of projects.
So I would suggest, unless as far as any specific questions, but what we might do to keep things moving tonight is let Kyle get through the presentation. And then when we come to those specifics, we can get into the details and the nitty gritty.
Sounds great. All right, so that's all of the basic development criteria associated with the Senate bills. Now I'm going to go into some of those portions of the bills that were not outlined explicitly that require some interpretation by the county. The first is that there's some specific language that the ADU cannot include more than 900 square feet of usable floor area. However, that term usable floor area is undefined in the bill. And so any county that undertakes a rural ADU program is having to effectively make up their own definition of what they think defines usable floor area. The second is that the ADU is required to be located no farther than 100 feet from the existing primary single family dwelling on site. I'll go into why that requires some interpretation in a second. The ADU cannot be used for short-term vacation rentals. The ADU has to have adequate access for firefighting equipment, safe evacuation, and staged evacuation areas. However, again, all of those particular terms are defined again within the Senate bill. And then finally, it has to comply with state wastewater regulations, which again goes back to this South County issue that we were just discussing. So some of those criteria that are subject to local interpretation, as I stated earlier, usable floor area is undefined. So we've had to craft our own definition here. In regards to the 100-foot siting distance, it doesn't expressly call out whether an ADU needs to be entirely within 100 feet of an existing single family dwelling, or if only a portion of that development needs to be in there. That does have some specific implications when you're looking at larger properties is primarily what we're referring to. It allows jurisdictions to go beyond the minimum acreage standards, that 2-acre minimum acreage standard, which is again why we've proposed that 5-acre minimum standard in Southern Deschutes County. And as I pointed out, it doesn't identify who should define or vet things like adequate access for firefighting equipment, safe evacuation routes, or staged evacuation areas. So here is our draft attempt to come up with some interpretations of all these. We've defined usable floor area as the area of the ADU that's included within the surrounding insulated exterior walls, but exclusive of garages, carports, decks, and porch covers. For the 100-foot siting distance, we specifically interpreted that as the ADU being located no farther than 100 feet from the existing single-family dwelling as measured from a portion of the single-family dwelling to the nearest part of the usable floor area of the ADU itself. So that doesn't mean that the entirety of the footprint has to be located within that 100-foot area. For adequate access, this one gets a little bit complicated, so bear with me. The accessory dwelling unit has to have adequate access, and it has to have adequate access to 2 specific areas, to a staged evacuation area, and it has to show adequate access to a safe evacuation route. A staged evacuation area we've identified as a public or private location that occupants of the ADU may evacuate to reorganize. And safe evacuation plan means an identifiable route on rights of way and any on-site driveways from the ADU to the staged evacuation area. Regarding adequate access specifically, though, we've had to further alter this specifically since the submittal of the previous commission's packet to identify some clear and objective standards. So as I pointed out at the beginning of my presentation, there's been some recent case law that anytime we're coming up with new residential regulations, we have to identify a clear and objective standard before we allow something like a more discretionary standard. So we've added in some new language with all of you have in front of you here. I've given you the most recent version of that draft code. And we've identified an adequate access based on some of our existing language in Title 17, which is related to our partitions and subdivisions, some comments from the Deschutes County Road Department and some of their definitions, and then finally some general road access standards from Fire Protection District standards and comments that have been submitted by fire protection officials. I'm not going to go into all the nitty-gritty details. It's pretty extensive and gets somewhat complicated. But if you look at the code and you refer to the adequate access section, you'll note that there's actually two specific pathways to finding adequate access. The first are these clear and objective. You can think of them as fairly prescriptive standards. So we basically identified if you build a road or a driveway to these standards, it's guaranteed to be adequate access. The secondary option is more discretionary, which is you either can't or don't want to meet that first standard. You can go to a fire protection provider, which provides emergency services to your house. And if they give some sort of written sign off that yes, whatever access you have to the ADU meets their standards for providing emergency services, we would also accept that as a secondary adequate access proposal. Does that make sense? I know that gets kind of into the weeds a little bit. So as I pointed out, adequate access, you've got those two possible standards, the prescriptive standards or the written confirmation from a fire service provider. So what does that look like in terms of a future possible application process? We would require an applicant to provide one, verification that they have adequate access, again, based on those two possible standards, a safe evacuation plan, which is a literal turn-by-turn directions essentially on how you would get to an ADU to your proposed staged evacuation area. And then the final piece is written authorization from whoever owns the staged evacuation area that they have been acknowledged as an evacuation point for residents of the ADU.
Is there any description of what qualifies as an evacuation area?
Again, I'll back up a little bit here. The definition we came up with, we intended to be about as broad as we could. So it's a public or private location that occupants of the rural ADU may evacuate to reorganize. So it could be grandma's house, it could be a storefront, it could be a church, it could be really anything that you have just identified as being in the general area that you say, if I'm forced to flee this.
The driveway outside the dwelling could be your evacuation area.
I don't think it could be the driveway outside. I think it would have to be somewhere off site of the property itself.
Okay, I guess that's all, because it
Public.
seems.
Parking lot down there.
Because it has to be a property, I think it can't be something like a right of way. I think it has to be, again, either a public or a private property. So a store, a church, wherever you want, a neighbor's house.
Is there a distance requirement?
No distance
Okay.
requirement.
Interesting.
I think we're leaving a little bit of this up to self-certification and the understanding that if you're choosing an evacuation area, it probably shouldn't just be the place next door. It should probably be somewhere that you should know will be a safe location if you're forced to flee, but ultimately that's at the discretion of the property owner and the developer.
Middle of the river.
Yes, safest place.
Yeah, I digress, but as a firefighter, there's a certain few cities that the entire town didn't qualify.
Fair point.
This was done at the state level, though.
I know, there's so many holes in it.
The next interpretive issue has to do with the South County parcel size. We've already kind of broached the subject a little bit earlier, but again, due to some vulnerable groundwater characteristics in southern Deschutes County, our on-site wastewater has recommended that we bump up the minimum parcel size to qualify for a rural ADU to 5 acres within that area. The boundaries of the area are identified in that USGS study that I referenced earlier, but it's effectively everything from the southern border of Sun River south to the border of Deschutes County. Wildlife resources. To the extent that our Goal 5 wildlife resources are affected by any proposed rural ADU findings, we've addressed those as a conflicting use. If you go into the staff report that you've been provided here, you'll note that there's an EASY analysis, which is an economic, social, environmental, and energy analysis that essentially is identified as a decision-making tool for both yourselves and ultimately the Board of County Commissioners to weigh the benefits of allowing rural ADUs in Goal 5 wildlife areas with any negative impacts that might occur with allowing those. We have a lot of areas in rural Deschutes County that have Goal 5 wildlife areas. Primarily, they're associated with our wildlife area combining zone. I know some of the commissioners are already familiar with this, but they're spread sort of all over. We have 3 big wildlife area combining zone sub areas. One is related to elk range, one is related to deer winter range, and then finally there's a pronghorn range as well. But really, it's just the first 2 that are affected in any way. Oh, I'll also point out that it's a part of that initial EASY analysis. You can go into the findings a little bit, but we have proposed as staff to allow rural ADUs with no exemptions or any additional limiting factors based on those findings. But of course, the commission is welcome to review those and make differing recommendations if they see fit. Wildfire mitigation. There's a lot of language within Senate Bill 391 and 644 dealing with wildfire mitigation, which I'll do my best to summarize. So as I stated previously, no properties originally would have been eligible for rural ADU development until the newest iteration of the state wildfire hazard map was released by the Oregon Department of Forestry. Just as a little bit of context here, I'm sure most of, if not all of the commissioners were aware, this state wildfire hazard map was related to a secondary Senate Bill 762 that also passed in 2021. And it requires the establishment of this statewide hazard inventory specifically related to wildfire. So it takes into factors things like climate, topography, vegetation, and existing development on site. Those are the big things that are all intended to be rolled into the map. And then it assigns a hazard classification to each property, each of the, I think, just shy of 2 million private properties in the state of Oregon. And based on that hazard rating, there are additional wildfire mitigation standards that come into place. They're primarily related to new building code standards or fire hardening standards for the construction of residences and defensible space standards. So the actual vegetation management around any new structures that are built in those areas. But in addition to all that just comes out of Senate Bill 762. There are specific requirements related to rural ADU development that go above and beyond what was required by Senate Bill 762. So with all that preamble, Senate Bill 644 again passed this year, and it states it essentially removed that requirement that the state wildfire hazard map be released before any rural ADUs could be development. And as a trade-off, it states that prior to the release of the hazard map, ADUs can be permitted, but they have to be built to the home hardening or fire hardening standards as described in R327 of the Oregon Residential Specialty Code. So this is a suite of possible things you could add onto your home. They're dealing with the siding on your house, the type of roof you might have in your house, windows, screening, basically a suite of options that a homeowner can implement to prevent their house from igniting during a wildfire event. Any ADUs built prior to release of this, whenever the new version of the state hazard map comes out, have to be built to these additional standards.
So essentially, once the map comes out, there may be another set of standards that these things could be built to, but they're allowing them to move forward and under the provision that they meet the most strict requirements.
So that's approximately right with a little bit of a caveat. Basically, what it says is prior to the release of the maps, all ADUs have to meet the strictest standards. After the release of the maps, only those properties that are identified as highest risk have to meet the additional standards.
So there would be potentially lesser standards
Correct.
if the map would allow it.
Exactly. Where presumably less properties would be identified as high. And so those properties that fell within both the low or moderate hazard classifications would not have to meet these additional building code standards.
And if I can, Commissioner Cyrus and Commissioners, what we're understanding, so Senate Bill 80 was kind of like Senate Bill 644's version, Senate Bill 391. Senate Bill 80 is affiliated to Senate Bill 762, which was the original wildfire mitigation legislation that came out in 2021. We're hearing that, just cutting to the chase, that the Oregon Department of Forestry would like to finalize a map by spring of 2024. Senate Bill 80 requires some robust public outreach, starting with county commissioners in the fall, which likely will happen at a district association of county meetings. For our district, it's going to be September 21st at the Running Y Resort. But there's several iterations. So the Department of Forestry engaged with county commissioners and their staff to provide input on where the wildland urban interface and the risk classifications are. Or Department of Forestry then releases, we'll call it map 2.0. 2.0 then is shared with the public for feedback. What that process is, we don't know yet, but so the public gets a bite at the apple for map 2.0. Then the Department of Forestry comes back based on that input and creates a map version 2.1. They then have to go back to the commissioners. The commissioners in effective counties have the ability to provide feedback yet again. And so based on that feedback, then I lost what version I'm on. I think it goes to version 2.2, which is the version that would come out presumably spring of 2024. The risk areas, instead of being low, medium, high to extreme, which was originally what Senate Bill 762 was saying, if you fell into high and extreme in a wildlife urban interface, you were subject to fire hardening.
From 5 to 3.
Correct. Yeah.
Right.
Correct. It went right. So now it's low, medium, and high, and only if you're in high and within a wildland urban phase. So we'll keep you informed, or Kyle will keep you informed about Senate Bill 80 this fall through those processes. So you can spread the word accordingly. But yeah, that's so it's presumably just forthcoming. Yeah.
Any questions about any of that? One thing that I did want to call out is Senate Bill 644, while it does impose these additional building code requirements for rural ADUs, one thing that it actually doesn't address in this sort of interim period before we have the hazard map are defensible space standards. And so what we've done to kind of bridge that gap that was intentionally or unintentionally left out of Senate Bill 644 is we've crafted some supplemental defensible space rules for ADU development, which occurs prior to adoption of that new hazard map, presumably sometime in spring of next year. The defensible space standards that we've come up with are based on our existing rules within the forest use zones, and they'd effectively be removed after the final adoption of the hazard map in a similar way that those building code standards wouldn't uniformly apply across all properties looking for ADUs. It breaks down again into two kind of a clear and objective standard, which are those forest use defensible space rules that we proposed, or as an alternative discretionary standard, you can work in conjunction with whoever your fire protection district is to get them to sign off on a specific defensible space plan for your specific property. And again, as long as you bring something certifying that from a fire protection district, we'd also state that you met the standards associated with defensible space on that property. So now I'm going to go through some of the agency and public comments that we've received on this proposal to date. We've gone through this a few times now, our existing On-site wastewater division has proposed that infrastructure should be sized for only one dwelling, and most properties, maybe not most, but a lot of properties are likely to require upgrades, expansions, or new separate systems to serve ADUs. Most properties that already have existing septic systems likely were not built to a size to accommodate a full additional dwelling unit. And so this is more of just a caveat for everyone to be aware that just because you have an existing system doesn't mean you can plug into that existing system for rural ADU use. Another big caveat here is that certain sites just may not be suitable for ADU development because of things like soil conditions on site, setback requirements, specifically setback requirements from septic systems and wells, and then any other site limiting factors. Could have strange topography, whatever it happens to be. As we pointed out one more time, in southern Deschutes County, based on USGS and Oregon Department of Environmental Quality, they've studied the area extensively, and DEQ has determined that water resources are at risk of contamination from on-site wastewater systems in southern Deschutes County, and that increasing the density and number of dwellings in this area that are identified as already exceeding sustainable nitrate loading. And based on this particular feedback from all these agencies, our on-site wastewater division again has recommended larger parcel sizes for any ADU development in the area. There are some general concerns from Fish and Wildlife, the Oregon Department of Fish and Wildlife, that allowing rural ADUs would constitute a conflicting use to wildlife populations and habitat. And based on those concerns, they've requested that the siting and fencing standards of the existing wildlife area combining zone be applicable to any rural ADU development. Staff believes that this likely would apply anyway. Rural ADUs are residential uses, and residential uses have these additional restrictions within the wildlife area combining zone already. So we haven't made specific language that calls this out, although we potentially could add that back into the code if needed.
They would need to be within I think that's the 300 feet.
Correct.
300 feet of the road, right?
Correct. Yeah. The siting standard requires either 300 feet of a road that existed as of 1992 or 50 feet of a driveway that existed as of 1992. And then the fencing standards are specific height requirements and material requirements for any fences that are built. There are some exceptions related to garden spaces, backyards, things like that, up to a certain size that can be built out of any type of fencing material. They also requested some sizing and dimensional limitations on any non-livable space associated with an ADU. So if you have garages that are attached, any type of accessory structures that might be used in conjunction with an ADU, they requested some type of sizing or dimensional limitations on those to reduce the overall footprint of these developments. And then finally, they requested that access to ADUs utilize any existing roads or driveways that are already on site. The fire districts, to date, only one fire district has provided direct comments on the proposed amendments themselves, although we have received other comments from fire protection districts, as I pointed out earlier, related to adequate access, although they didn't relay those as formal comments to say you should do these types of things. It was more of a discretionary opinion. This would be sort of the best standards to go through. But in this particular case, Lapine Rural Fire did provide some comments to us. And they specifically requested that the Oregon Forest Land Urban Interface Fire Protection Standards need to be maintained for any rural ADU development. They want to ensure that the Oregon State Fire Codes need to be maintained, including access and water supply standards. And then finally, they want to ensure that we fully adopt and implement the state's new structural hardening codes. Those are those Senate Bill 762 issues that we talked about earlier, and that any new accessory dwelling unit be fire sprinklered.
So is that fire sprinkling means the inside of the unit, not the exterior, right?
Correct. Ultimately, I will point out that the fire sprinkling, we have not included that in the current draft amendments right here. It's a relatively contentious issue. There's definitely back and forth, even between our building safety division. Certain things are required to be fire sprinklered, certain things are not. But for the time being, we've elected to not follow up on that specific request.
Yeah, it seems like that's usually due to low flow in the water system, right? That's when they require for fire protection, like the fire hydrant, or I've ran into it in neighborhoods where there isn't enough fire flow in the water system for fire trucks to come extinguish fire, so they require sprinklers inside.
That I'm not sure of.
Okay.
I think it may just be an additional protection standard that was requested, given that we have increasing wildfire concerns and
Yeah.
structural fire concerns.
Got it. To keep it from starting inside of the house and burning the house down. Yep,
Right.
that makes sense.
We had some comments from the Oregon Water Resources Department. These were specifically made in connection with some public comments that we received regarding impacts to wells and groundwater resources that might be occurring related to additional ADU development. And OWRD specifically pointed out that under current Oregon law, a landowner is able to drill a well and use that well for exempt uses as described in the ORS. Those are domestic residential uses, lawn irrigation, things like that. There are certain limitations on the amount of water that you can use under those exempt uses. And landowners are not allowed to drill 2 wells on a piece of property and then double the amount of exempt uses, including for the purposes of constructing rural ADU. So under pursuant to Senate Bill 391 and Oregon water law, if you build an ADU, all of your water use associated with your primary dwelling, as well as the ADU, have to fall under one exempt use groundwater permit, which is
So you essentially you split the use rather than doubling it.
exactly. As you point out, yeah, the 2 separate dwellings on a single parcel only qualify for a single exempt use. They also wanted to point out that some of the recent decline in the water table in Deschutes County is due to 3 primary causes. The first and most important is that the last 20 years have been drier than average. And in the past decades, there's been less recharge in the Cascade Range to our aquifer. The second most important is the increase in the number of uses overall in the basin has led to a direct lowering of the water table. And finally, lining and piping of irrigation district canals has caused at least some marginal impact on water table lowering. However, private well uses in the area are exempt, and the entire basin is approximately 6,000 acre feet of water annually. That's all of the domestic wells in the area use approximately that much water in a year. And the average annual basin recharge is about 2.5 million acre feet generally on an average basis. So domestic uses make up a very small fraction of overall water use in the basin. And thus OWRD is not super concerned that allowing these additional, let's say somewhere between 8,000 and 9,000 additional dwelling units in the rural county is likely to have significant impacts on groundwater resources in the area. Some of the draft code language that I'll point out that deals directly with this. As required by Senate Bill 391, an existing single family dwelling and an ADU allowed under that section are only calculated as a single unit when determining exempt uses under Oregon water law. So we're required to put that specifically in the bill, and it's included in the draft language in front of you. They do believe that limiting the number of wells on a parcel of land is probably a best practice, as it reduces the potential for aquifer contamination and the ability to unintentionally or intentionally exceed exempt use limitations. I'll point out that Senate Bill 391 does allow jurisdictions to explicitly require that ADUs be served by the same water supply source as the primary dwelling. So we could potentially draft language that says an ADU has to use the same well as the existing primary dwelling on site. However, at this point in time, we've elected not to include that language just to provide flexibility for property owners if for some reason their existing well just can't serve 2 dwelling units at the same time adequately. Ultimately, however, water rights and well permitting, those are issues that are overseen by OWRD, and they're not really within the realm of land use. So we don't have a lot of authority to enforce some of these water rights laws and restrictions, even though some of them are explicitly called out in Senate Bill 391. We did have some comments from some water utilities, private water utilities in the area. They've specifically requested that if any rural ADU developer is going to be served by a water source other than an on-site domestic well, that that developer provide the county with what we describe as a will serve letter or a willing and able to serve letter prior to us issuing any type of development permits. This is basically just an acknowledgement that they've spoken to whoever their utility provider is and that they actually have the capacity and the infrastructure to provide water to that property. This is a pretty common thing that we require for any type of partition or subdivision, usually for things like water, sewer, electricity, so that people aren't building things in the county that then can't be served by whoever the existing utility districts are. Your new draft code language includes this provision as requested by the private utilities. Now I'll go into some of the public comments that we've received. To date, we've received 16 public comments on the draft language. 7 of those comments have expressed support, citing general benefits to the county, including increasing housing supply, increasing opportunities for intergenerational housing and living, and increased economic activity from rural ADU development generally. 9 of the comments express opposition to the proposal, citing things like traffic increases associated with more dwelling units in the rural community, impacts to water and wildlife resources, increased wildfire risks, skepticism around impacts to the housing affordability crisis that we have in the region, and the loss of open space and the rural character associated with unincorporated Deschutes County. Now, the last piece that we'll talk about here is the previous commission actions. So as we stated earlier, you guys have already seen a version of this, or at least most of you have already seen a version of this last fall, although we have 2 new commissioners who haven't had the opportunity to weigh in yet. But for both your benefit as well as their benefit, I'll go through what the previous recommendations on the draft proposals were. So we held the initial public hearing back in September. We had 9 individuals provide testimony during that hearing, and the testimony was generally split between parties that were in opposition and parties in support. It was in the same way as a lot of the written comments. We saw general concerns around impacts regarding traffic, wildlife, and water resources, et cetera, et cetera. And then on the positive side, people saw this as an opportunity to relieve some of the housing burden that we have in the county. The commission ultimately held deliberations in October and provided the following. They recommended adoption of the proposed amendments with some significant alterations, which I'll go through here. That was approved by a vote of 4-2. The second related to the usable floor area definition that staff proposed. And ultimately, the commission recommended altering our initial recommendation to restrict usable floor area to the area of the ADU included within the surrounding exterior walls, and also including garages and other accessory components. So unlike what's in front of you now at staff's recommendation, which would exclude things like accessory components and garages, this would have essentially gave you a 900 square foot box that everything had to be within. There's a little bit of nuance here that might be helpful to go into. Some of these concerns related to the fact that if you allow things like accessory components attached to an ADU, it'd be very difficult for staff or really anyone that's reviewing these proposals to evaluate how they might be converted into usable floor area over time without staff's knowledge, and thus superseding the requirements of Senate Bill 391. And so in order to avert some of those possible restrictions, essentially they said, yep, you should just get the 900 square foot box. Everything has to fit within that. If you want a garage, that's fine, but that has to come out of the 900 square foot minimum. It's also important to point out that any developer that wanted to build an ADU technically can build a non-connected accessory structure right next to an ADU or their existing primary dwelling, and the 900 square foot limitation goes away. So if you want to build a 2,000 square foot garage next to your 900 square foot ADU, essentially that would be allowed under both the current rules as well as the amended rules.
Is there any distance requirements? Like, does it have to be a certain distance away from the ADU?
No distance requirements other than safe siting distance related to the building code standards. But there's nothing in the land use that would require it to be within a certain distance. That 900 square foot limitation, again, as I stated, would apply to the entire structure via the previous recommendation, and that was approved by a vote of 5-1. The siting distance standards, the commission agreed with staff's original interpretation that only a portion of the ADU needed to be within that 100-foot siting distance standard rather than the entirety of the ADU footprint. And so that was unchanged from staff's initial proposal, and no vote was taken. The South County groundwater standards. As we pointed out, there's some concerns related to vulnerable groundwater characteristics in that portion of the county. And the commission ultimately recommended that staff's initial proposal to increase that minimum parcel size up to 5 acres be unchanged. Related to Goal 5 wildlife areas, again, our wildlife area combining zone, as well as some other areas in the county. The commission ultimately recommended prohibiting all rural ADU development in designated Goal 5 resource areas throughout the county. That includes primarily our wildlife area combining zone, but also our greater sage grouse area combining zone and our sensitive bird and mammal habitat combining zone. So under that recommendation, no ADUs that fall within those areas would be allowed. That was ultimately approved by a vote of 5-1. Regarding Senate Bill 762 and wildfire mitigation, the commission initially recommended delaying the adoption of any local ADU legislation until such time as the state wildfire hazard map, at that time it was called the risk map, had been released by the Oregon Department of Forestry. The commission wanted to see what the final map actually looked like before allowing any new rules where ADUs could be ultimately improved. That was approved by a vote of 6-0. However, as we pointed out, the state rules have changed regarding that. And pursuant to Senate Bill 762, that recommendation may no longer be applicable. I ultimately leave that up to the commission to decide, as there are some interim wildfire mitigation building code standards that have been included in the draft amendments pursuant to Senate Bill 762. And then, as I pointed out, we've also created some supplemental defensible space standards during that interim period before the state wildfire hazard map is released. The West Side Transect Zone, for the commissioners that may not be aware, the West Side Transect Zone is a very recently approved zone in Deschutes County. It is on the western edge of the city of Bend. It was primarily intended as a piece of compromise legislation between environmental groups and some land use interest groups in the area, as well as developers. And it was intended to provide sort of a feathered or buffered development potential along the western edge of the city of Bend to lead into national forest lands and some resource lands along the western boundary of the city.
Is that mostly like the Tree Farm, Westgate, and those neighborhoods that are kind of along Shevlin?
Westgate is a part of the West Side Transect Zone. The Miller Tree Farm is not a part, but the West Side Transect Zone has a lot of standards that are specifically based on the Miller Tree Farms development code. So it requires a couple different things that are important to point out. One is slightly larger parcel sizes that might otherwise not be allowed in the area if it were ultimately pulled into the city. It requires the production of a wildfire mitigation plan for all developments that occur in there. So every time a subdivision is approved, they have to put together a big report that says, these are our wildfire risks. This is how we're going to mitigate that risk, both at a subdivision level and an individual parcel level. And then the last piece is the production of a wildlife protection and habitat management plan. So there are specific areas that have to be identified as wildlife corridors or dedicated open space, and a plan in how those areas are managed for wildlife habitat over time. Again, this was a big piece of compromise legislation to allow development in this very desirable area adjacent to the western edge of Bend, but to prevent it from ultimately being pulled into the city and being developed at urban densities. So you get some houses, they have very specific requirements to protect against wildfire hazards and wildlife to protect wildlife habitat, but ultimately to prevent very dense development that might otherwise occur. The reason this is important to point out is, given that compromise legislation, the commission felt that it might undermine some of the initial intent of the West Side Transect Zone to essentially double the number of potential dwelling units that could be allowed in this area. And ultimately, the commission recommended prohibiting ADU development in the transect, and that was approved by a vote of 6-0. The last piece I'll talk about here is vacation occupancy. So as we pointed out earlier, Senate Bill 391 specifically prohibits that any ADUs that are built cannot be utilized as a short-term vacation rental. And that has 3 specific requirements that all have to be pursuant to state law. The occupant rents the ADU unit for vacation purposes and not as their principal residence. The occupant has a principal residence that is not the ADU, and the period of their occupancy is 45 days or less. So all three of those requirements have to be met, and that would constitute that particular dwelling unit being utilized as a vacation rental. Given the concerns regarding removing potential housing stock and placing it into vacation rental use, the commission ultimately recommended prohibiting both the primary dwelling on property as well as the ADU from being utilized for vacation rental purposes if they want to construct an accessory dwelling unit. So if you elect to pursuant to this recommendation, if you were to elect to build an ADU, you'd be forfeiting your right to use both of those units for vacation occupancy at any point in the future. That was also approved by a vote of 6-0. Some general discussion points. A number of the commissioners expressed some concerns that ADU amendments were being presented prior to the completion of some other long-range planning initiatives that might affect the proposal. Specifically calling out the state wildfire mitigation, Senate Bill 762 mapping efforts, and the Deschutes County Comprehensive Plan update, which Peter discussed earlier during your meeting. Both of those projects are still underway. They haven't been completed yet. Comprehensive Plan update is likely to come before you over the next few weeks. And so some of the commissioners wanted to see that process completed before moving forward with these supplementary legislative amendments. So some next steps here. That's a lot to go through. The commission ultimately will need to provide any new or modified recommendations for the board's consideration tonight. You're not going to have another opportunity to review this, and ultimately you won't have a secondary public hearing. And the board will be conducting a public hearing on both the proposed amendments as well as your recommendations on July 26th. And with that, I'll just open it up to any questions.
Anybody have questions? Or are you ready to dive into it?
Yeah.
Okay, thank you. I would suggest, unless somebody has a better idea, that we go through the matrix issue by issue. And my suggestion would be that we consider, unless there is no motion to the contrary, that we consider the staff recommendations as something we're good with unless we have a motion to the contrary. Does that make sense to anybody?
Sure.
In order to keep things moving?
Yeah, that sounds good to me. Also, Commissioner Altman, I sent you a digital copy of the decision matrix since everybody else has a physical copy, so you should be able to follow along.
Okay. With that, number one, should rural ADUs be allowed with additional standards or prohibited? And you can all read what the current amendment standards are that are proposed in that column. And I guess the question is there a motion on this one?
So we have if I'm understanding this, and we're looking at item number one, correct?
That's correct.
Okay, so current amendment standard is including West Side Transit Zone.
So I would just read this to say, do you want to allow rural ADUs?
Yeah, I guess
Okay.
that would be was it as a general term, then the others actually get into the details.
Okay.
If that makes sense to you
Yes.
guys. Okay, then unless there's a motion to the contrary, by consensus, we'll approve number one and move to number two.
Okay.
And then when we get all done, we'll take a vote to approve the whole package. All right, number two. How do we want to define the usable floor area? You can read through the current amended standards, and it would define them as usable floor area is the area of the building that surrounded by exterior or insulated exterior walls exclusive of garages, carports, etc. Is there a motion to the contrary?
No.
I have some thoughts on that one.
Sure. Go ahead.
I mean, usable floor area is typically heated square footage, and that's
Which the size is the size. This is one of my thoughts on this, limiting it to 900 feet. And it actually has more to do with using existing structures on a property. Say you have a 2,000-foot shop near your house that's right there, and you could utilize some of that space for an ADU without actually even building another structure. And that would be one of my concerns. Like you could provide the ability to make an ADU without having any impact to the property and put it in there, but under that, it would prohibit it. So then you'd be forced to build another building next to the shop. That would just be one of my thoughts. And the cost to do it, it would be a lot more affordable to do it if you could build inside of an existing structure that's there. So it's just a thought I have.
Yeah,
Like,
well, and I would agree with you, quite frankly.
Is-
I'm aware of
Is
dozens.
the 900 square feet, the state rule though?
Yeah, so what we did the last time around is we made a recommendation that the 900 square foot include the entire structure. And I would tend to agree with Commissioner Trowbridge that if we went to just the 900 square feet as the livable area, that would allow us to bring into compliance, my guess is probably thousands of existing illegal ADUs in this county. I personally know of a few dozen of them where people have built a dwelling unit in a barn or shop or other existing space that under this could be brought into compliance, whereas otherwise those units would continue to be hidden and they just build another structure.
yeah,
Go ahead.
I have a comment on that is I think a lot of those units are so far out of compliance with septic systems and other, features. Why would someone bring them into compliance? Why would someone bring the attention to?
I guess my thought from a real estate standpoint, I mean,
Value.
there's
You could split it.
disclosure issues and the fact that somebody's going to find out that there's an illegal use on the property, whereas maybe it could be brought into compliance, might be easier to sell it then.
a lot easier because you can't.
But isn't it the state that's saying 900 square feet?
Well,
Am
I'm
I,
saying 900 for just the living space.
Now, if you've got a 5,000 square foot barn and arena and et cetera, and it just happens to have a 500 square dwelling in it, and I think you've got a question or
No,
comment?
no, I was just going to add to the discussion. The other part that the county deals with is code compliance. So if there's a code investigation and somebody's illegal ADU is at issue, then that question or comment about legalizing that could be a possibility. Again, if the wastewater, and I mean, there's plenty of other aspects that go into a decision for a property owner to come into code compliance, but and Kyle, go ahead.
No, I was going to say, so just for consideration, there's a couple things that might want to be weighed into this discussion. One is the 900 square foot thing does come from Senate Bill 391. So that overall number we can't really change. The question of what constitutes, the other thing that I might point out is, and this is a long running conversation that we've had with both our building safety division as well as other officials, is trying to identify what constitutes living area is a very difficult thing to do. It's not clear what things should be included in that. Can you have, let's say, a washer dryer, and does that then begin to accommodate living space? Does a shower constitute that? Does cooking
Absolutely. If it's a
facilities?
heated square footage, it is usable floor area. That's a standard in real estate that's been, but you basically, when you say you have a 3,000 square foot house, that does not include the garage, any parts that are not inside of the heated envelope of the house.
And that's
That's usable square footage.
correct. Yeah, that's,
So
and
900 feet of usable square footage would be finished living. Usable floor area means finished, heated.
so would we possibly look at adding existing structures? So any newly built ADU has to be 900 feet, but an existing, I mean, I don't know, is that something that could be said? And not the whole entire existing structure, but if there is an existing structure, could 900 of it be permitted with insulated walls, et cetera?
Theoretically, yes. I think one of the issues that you run into, and you'll see as one of the possible alternatives that we've listed here, is one way to get at this is while there may be a real estate definition for something like usable floor area, living space, in terms of applying that to something that we can evaluate either as planning professionals or someone on the building safety division, it tends to run into a couple different issues. One is the actual permits that are applied to whatever that space is. So the building safety division uses something like R3 permits for residential spaces. And then they have other types of building permits that they apply for spaces that are not intended to be inhabited, so-called U permits. One of the issues that you run into is that it's very difficult to apply certain types of permits to existing structures, but then other permits to other types of structures. Particularly if one of the big concerns that was at least brought up during the previous discussions is how do you stop someone from converting let's say a U approved area, a structure that's not intended to be inhabited into what amounts to living space after the fact, if that makes sense.
So Commissioner Altman?
Yeah, thanks, Chair. I was frozen. I had to log off, and I'm not able to start my video because it says the host has stopped my video. So I just raised my hand to see if I could have my video.
Thank you.
Thank you.
So I guess my thought is, like you say, unless there's a motion to make a change, I would suggest we accept what's proposed as the current amendment standards and move on. Is there a motion otherwise?
What do you mean the current amendment? Like,
And in the center of your proposal,
You accept that.
what I had suggested is that unless there's a motion to the contrary, we accept what's proposed as the current amended standards.
okay, from the state.
Correct, from the county that was put together as a recommendation for us.
The recommendation is limited to 900.
No, we're looking at the center column that says current amended standards. Unless you would prefer the other language, in which case I would accept a motion to that effect.
I like the usable floor area.
Okay. So if there's no motion to the contrary, we'll move on to number 3.
100-foot.
And this one would propose that the 100-foot be measured from the closest points versus, and one of the alternatives would be that the entire unit would have to be with 100 feet.
Yeah.
So if you're good with that, we'll move on.
Reasonable. I mean, you run into all kinds of issues anyway when you start to go past 100 feet, power, just
Sure.
water delivery, all kinds of things. Just
Okay, with that, number 4. And that would be to limit South County to 5 acres and above. And I know this is one where you had an issue of concern. If there's some alternative language that you'd think we should take a look at, now would be the time.
it just seems to me that I don't, and again, I don't feel strongly either way. I just want to understand it in a way of what is the difference between 2 and 5 other than limiting the amount.
Just density and loading.
Yeah.
And that was the recommendation from the sanitation folks.
Yeah.
And I guess the question is is there some alternative language that you think would be appropriate as an exception or to that rule if they were to meet certain criteria?
I'll also point out each of these options also, I mean, they're possible alternatives that we as staff have kind of hypothetically come up with. Obviously, you can use that as a starting point. You can come up with something on your own. I mean, recommendations are ultimately up to you to come up with. We just have some, that was our initial draft assessment.
Yeah. So here's some alternatives.
What we're kind of discussing right now,
Okay.
this is what the county's recommending.
It just seems like it's more versus size. It's more about,
I know a lot of the properties in South County, there's the water maps. Some have very high water tables. The water tables are lower. They have the different color maps. And they're, some areas are very critical, like you just cannot have wastewater. I mean, the water is essentially at ground level. So I understand that. It just, even if you had a 5-acre lot, it seems like you could have a 5-acre lot that has a way more critical situation than a 2-acre lot that is in a better area. So it just seems like that one is, and this is my opinion on that, because I have some experience with properties down there, is that the blanket 5-acre, I just don't think that achieves the goal of protecting the groundwater as good as specific study of specific lots.
So I guess I would ask if there is a specific criteria that you think would work better. For example, an engineer's report or DEQ support of that we leave the minimum at the 2, subject to site specific approval from sanitation and or DEQ. I mean, quite frankly, maybe 5 acres or 10 acres isn't sufficient based on.
It might not be, yes.
So one thing that I'll point out that I don't want to be misleading here is the 5 acres is separate from site specific approval for on-site wastewater approval on any property. So regardless of what the minimum acreage is, each individual property owner is still going to have to go to the on-site wastewater division. They're still going to have to receive approval, in which case, depending on those individual characteristics, they may require something like an AT.
So in theory, none of them may be approved regardless of lot size.
Exactly.
So I guess then, does it make sense to put a minimum acreage if in fact they all have to have site specific approval anyway?
So I think, again, the overall goal was, as you pointed out earlier from the on-site wastewater division, was to decrease the possible density in this area because of the sensitive resources and the ongoing contamination impact. And the addition of, at my understanding, based on the comments from Todd and others in the on-site wastewater division, is the addition of any additional systems in the area is going to have some type of an impact. The purpose of the 5 acres is, again, a compromise piece of legislation that does reduce the overall density and still allows some possible ADU development in this region.
How many that it reduces it by when you raise it to 5 acres from 2? How many properties are no longer eligible?
You give me a second.
I think it was roughly 1,000 if I
It's
recall.
approximately 1,000 though. Yeah.
Okay.
But I can tell you the specifics.
9476 versus 8360.
Something like that.
Yeah.
Let's see.
So
So
any specific suggestions?
I guess if that's the goal, is to limit the amount of ADUs, you guys can decide on that one.
Well,
Commissioners, for the record, Will Groves, your planning manager. I think you're tracking on this correctly. In my discussions with Todd Cleveland, which I hope I'm representing correctly, he believes the correct number of ADUs in South County is 0. That the groundwater resource and the septic systems are overtapped there. There's a number of existing lots that already have legal rights to come in on those properties. So there's going to be, under just natural development patterns outside of the ADUs, that resource is over allocated. And so there was a question about if we didn't want to say if the answer that's going to be palatable to the public, to the board, to the commission isn't 0. Is it, the full suite of all ones that could possibly receive approvals? Because you could be on a 3-acre lot and potentially be on very high ground that, has very suitable septic systems. You could be on 10 acres and it all be swamp, right? So the acreage of the property, I think you're tracking correctly, is an arbitrary way to limit the total population. I think some other way you could do that is you could say, look, we're going to give out X number of first come, first serve permits, and then the party's over, and we don't care about acreage.
I guess I'm kind of leaning toward the don't put a minimum on it other than what statute says, and let the septic feasibility per site dictate whether or not And if county sanitation folks determine that none are appropriate, that's not our issue. I think that's based on the site
I think another thing to consider too is.
or sewer or whatever.
So another thing I think that I don't know if it's been brought into the conversation. So a septic system is sized by bedrooms in the home, not by bathrooms, because bedrooms are going to be what generates the waste. How many people can, adequately live in that home? And I think, and again, this is a tough one, in my opinion, to rush through because there's so many different aspects to talk about. So someone could have a 2-bedroom house on their 2-acre lot, and they want to add a 1-bedroom ADU for their aging mother or parent, and it really has no added impact. It's basically a 3-bedroom home on a system. So and that's where I have a hard time just saying no, because this is all bad, but then the guy next door can build a 5-bedroom house and he's good to go, but the person next door was going to have actually a lower impact, just a different multi-generational living system or setup. So that's where I have a hard time just saying, yeah, blanket. My brain goes into the specifics and I think about, well, what makes sense and what goes back to this, essentially septic science or that kind of a thing. So that's why I have a hard time just saying, oh yeah, 5 acres is going to cure all that, because it's not. That's all.
I'm inclined to stick with the 5 acres, and only because I've been in the South County for so long and we've been dealing with the DEQ for so long. I'm on 2 acres. My next door neighbor's on 2 acres. Their next door neighbor's on 2 acres. I could not imagine adding more load. I couldn't. So I would be inclined to stick with the 5. And I also know that we voted, I believe, 6-0 for the 5.
Correct. In the previous recommendations. Another thing that I may or may not be valuable for this is I think at least one consideration from Todd, even though, I know he's not here to speak for himself, is at least one benefit from what you can think of as pre-excluding certain properties rather than forcing people to go through the process of applying for something like an evaluation permit and then denying them after they've potentially already design professionals and committed some cost into it, is that you wind up disappointing people who've already committed some significant resources potentially towards a failed quest.
Okay. So what I'm hearing sound like by consensus, we're good with the recommendations from the county?
Sure.
Okay. We'll move on to number 5. And that's ADUs in wildlife areas. The staff proposal is to allow ADU development in designated wildlife combining zones, subject to existing standards.
Kyle, why did the staff go against the planning commission recommendations, even though I think the slide said that I'm not going to use the right word, but that it would be in conflict with goal 5?
So this is a little bit confusing. Our recommendations don't take into account the previous planning commission's recommendations at all.
Yeah, no.
These are just the initial recommendations that the draft language that
These are the ones that we discussed prior, and then the vote was to make differences.
So the only
you
things that
voted to prohibit, and they're now coming back.
No, this was what they had before.
Oh, originally. Oh, okay.
And that's what we
Okay.
were asked to readdress the whole package.
Okay.
And
Okay. I get
that was why what I suggested is that unless we have a motion to change to something different, we'll keep moving down this column.
Okay.
So if you like the previous recommendations, then it would be appropriate to make a motion to that effect,
Okay.
if that makes sense.
Yes.
I was just trying to be
No,
expedient.
no, I hear you. I hear you.
I know this is a little confusing because normally we wouldn't have a re-recommendation process
Yeah.
for some of this.
Yeah, the current amendment standards are what we saw last time.
Okay. Okay.
And then
We're
we
just seeing the same thing.
voted to approve
Yeah.
the column on the right.
I got that part. It just,
So the idea is we're a second bite at the apple to decide
Yes.
if we want to do something different, given that we have a different makeup of
Yep.
the commission.
Exactly. Okay, I get it now. I would make a motion then that we stick with the original recommendation by the planning commission of not allowing ADUs in goal 5 zones or areas, not zones, resource areas.
So your motion is to prohibit ADUs in
Designated goal
goal
5
areas.
resource areas, yes.
Okay, is there a second?
I'll second that.
Yeah, I'll second that.
Okay, it's been moved and seconded. So now, is there any discussion along those lines? The maker of the motions.
We discussed this at great length, and unfortunately, I know these commissioners that have joined us were not within that bubble of talk. We just our wildlife resources are sensitive, they're declining, they're fragmenting, and there's a lot of area that can be built that does not have to include this area. And this area is already kind of excluded in the first place. You can have your home in some of these areas. So I would feel that we stay with the norm of trying to protect our goal 5 resources.
Okay, any other discussion? I think I would offer a comment that I would disagree with the proposed amendment, in that in all of the research and studies that I did with regard to the mule deer overlay recommendation, what I found was evidence to the contrary, that in fact the deer tend to migrate to rural developed areas in order to get protection from predators. And in fact, Fish and Wildlife admitted that rural development was only roughly 3% of the problem. Number one being predation, 2 was poaching, 3 was legal hunting, and 4 was car strikes. And that residential development within the deer areas were roughly only 3% of the problem. And in fact, there was a really good study out of UCLA where they specifically studied deer habits versus development, and found that the deer, like I say, in fact, migrated to developed areas. And in fact, my personal observation is that you find deer in more populated areas in higher concentrations because there's less likelihood of predators. The first fawn I saw this year was actually walking across the street in downtown Sisters with its mother. I'm with the cougar population increasing, I'm not even seeing deer in our hayfields anymore like I have in the past because of the predator problems. So with that, I would oppose this change because I don't think it addresses the problem.
Would you consider the other resource areas besides the wildlife area combining zone? For
Such as?
sage grouse, sensitive bird, and mammal habitat.
Actually, no. I have the same observation with be it bald eagles or whatever. These animals have chosen to nest in the populated areas because, like I said, the bald eagles are frequent on our farm. They clean up the afterbirth from the animals or anything that dies. The bald eagles actually come to habitat or to populated areas. We find them in residential areas just as much as in wild areas, and I've actually run heavy equipment right under a bald eagle nest. I mean, granted, we threw a dead coyote out every once in a while to help feed her, but she fledged just fine with all the activity literally within hundreds of feet of her nest. My observation is that these protection areas are unnecessary and actually contrary to taking care of the wildlife.
Well, and at the end of the day is an ADU next to an existing home going to make, what does that impact? Again, I mean, where does the opposing that come from? Like, what does a ADU, what will do?
So I mean, it's kind of whatever. Oh, sorry. Commissioner Altman.
Thanks, Chair. Yeah, my comment about that is, you ask what does an ADU do? A building by itself, I think, does nothing in particular, but Commissioner Cyrus did point out to one of the causes from one of our other meetings about the decline in numbers, and one of those is being killed by cars. And if you're increasing the number of residents in a wildlife area zone, you're potentially doubling the amount of cars. So that just increases the risk for, let's say, mule deer, because that was our most recent conversation. So, I got to plug in my PC. That's my comment. Thanks. I'll be right back.
Thanks. Anybody else? Okay, let's vote then. All those in favor of the amendment to prohibit rural ADU development in the Goal 5 resource areas, respond with an aye. Commissioner Trowbridge.
No.
Commissioner Williams.
Aye.
Commissioner Kelly. Commissioner Altman.
Aye.
And chair votes no. All right, number 6. That's a long one, so I'm not going to read it. I'll let everybody read it themselves.
Yep. I'm in agreement with the current amendment standards. And one reason I would say is now that we have split kind of 391 and 762, and things have to be fire hardened no matter what until we have a decision, I see no reason to delay. And considering that some of the other discussions that had been proposed are now off the table, I think that's another reason to kind of just move forward with it.
Okay. Any other comments?
I agree with that.
Okay, well, then we'll move on to number 7. I can find it. These have to do with the West Side Transect Zone. What's your pleasure?
I move that they be prohibited in the West Side Transect Zone. And that's my motion.
Okay, is there a second?
Nope.
I'll second.
Okay, it's been moved and seconded. Would the maker of the motion like comment?
Yes, Kyle explained in good detail how a compromise was made to allow for a blending from going from Bend out into the wilderness, and there was specifically set larger lots so that there would be fewer people, and it contradicts what that agreement was made. And that's it. Again, it was another one that I think we were 6-0 on.
Correct. Yeah.
Okay, is there any other discussion? Nope. I guess I would ask if, given the fact that all of these have to face the new hardening requirements and that they all provide fire access, and all of the other issues that address wildfire, whether it still makes sense to prohibit them in this area.
From what Kyle said, I thought it was more of a specific density, not agreement, but
So generally, not to go way down the rabbit hole of kind of the background of the Transect Zone, but it really had two broad goals when it was ultimately passed. The first, as Commissioner Williams pointed out, was to provide kind of this lower density blend out into both the national forest and some resource zone lands on the western edge of Bend. That was kind of the overarching goal. The more specific kind of secondary goal was to provide for a combination of wildlife habitat protections and wildfire protections. So even outside of Senate Bill 391 or Senate Bill 762, all development in the West Side Transect has wildfire mitigation protection standards in place. So they actually already have to build, even the existing single family dwellings have to build up to fire hardening standards. They have defensible space standards, et cetera. The second piece of that is the preparation of wildlife habitat plans, which requires a certain amount of dedicated open space and the maintenance of those particular open spaces specifically for wildlife habitat. And one of the portions of that was limiting the overall density to allow for a greater amount of feasible wildlife habitat within the transect zone. So those are the overarching goals of passage. And at least the comments that were submitted that specifically requested prohibiting this in the transect zone by members of the public specifically called out that allowing ADUs in this may intentionally or unintentionally sort of undermine that overall goal. Ultimately, that was what the commission previously voted on and recommended to disallow it based on those factors.
Right. And I guess I was just kind of rethinking the whole process on that. If they still meet the criteria for the wildlife hardening, or excuse me, wildfire hardening, all the spaces, the wildlife, everything else, is there a reason not to allow them to have an ADU, assuming they meet all those requirements?
I think that would be up for the commission to ultimately decide, at least in regards to the comments that specifically requested disallowing it. I think it ultimately boils down to effectively doubling the.
So I guess to that issue, those who were asking that it not be allowed, how many of those actually were affected by it and lived in those zones versus somebody that's just lives in Portland that just says no growth?
That I can't answer that question. I don't know.
Because I know there is a certain element in the community that opposes everything regardless. And I guess that's my question is are these the actual people who live there are asking that we maintain that? Or are these activists that just say we don't want anything regardless?
That I don't know. Again,
Okay.
I would just defer you to the comments that were submitted specifically in that regard.
Do we know if that neighborhood has CCNRs that prohibit them already? Like, because it's mostly Westgate.
It's Westgate, Skyline Ranch is the second one, and then there's an undivided property that's included in there as well.
So there's more than just Westgate. Okay.
Correct. Yeah, Westgate was the first one, but there's a second one that's since been divided and planned.
How large are those lots?
2.5 acres.
2.5.
Some of
Okay.
them are bigger as well. And
There's
Westgate.
there's a
5.
there's a few larger ones just based on the platting, but the minimum parcel size is 2.5 acres.
Any other comments?
Nope.
Okay. Commissioner Trowbridge, how do you vote?
I would vote no on prohibiting that.
Hey, Commissioner Williams,
Aye.
Commissioner Kelly,
Vote to prohibit it.
okay. Commissioner Altman,
Aye.
and chair votes no. All right, number 8, vacation occupancy. The current statute prohibits the ADU from being a vacation rental, but does not address whether or not the original dwelling can or can't be.
Correct.
And the county basically is following state statute with not address the existing building.
Correct.
Okay, is there any Discussion. Commissioner Williams.
I would like to stick with the planning commission's original recommendation and move that we prohibit the primary residence from also being or from being a vacation rental either.
Okay, is there a second?
I'll second.
Okay, it's been moved and seconded. Your comment is first.
So we've been talking about increased traffic and we had discussed in previous meetings that if the ADU could not be a vacation unit, then it could have the homeowners move into it and have their primary residence become a vacation rental, which typically will see 2 to 3 times as many vehicles and people and foot traffic coming through the property, which is against what we've been wanting in our rural characteristic of our county.
Okay, any other comments?
I've been watching vacation rental frequency lately, and it's pretty much cratered, all but cratered. There isn't really, I think this one's kind of a non-issue other than I think it's already prohibited to use the ADU as a vacation rental. I just think people aren't doing it as much. I think a lot of these are getting converted back because the market has pretty much dropped considerably. So I don't think it's as big of a deal as people think. And I also think, I mean, I guess, yeah, the case of having the added impact from, I've seen that firsthand, the neighborhoods being affected. Can I not have a vote on that?
You can you can abstain.
I abstain.
Well, we haven't called for a vote yet, but
I'm
anybody
learning.
else?
No, I mean, I think that the intention of this is to create local housing. And by opening up the primary residence for a vacation rental defeats that purpose. So that's my,
And I would tend to agree that, I mean, it kind of defeats the whole point of adding an ADU to address housing.
Yeah.
So, is any other comments? Okay, Commissioner Trowbridge.
Nope, I'm good. No comments.
Okay, Commissioner Williams.
So are you voting yes, no, or
He
abstaining?
abstained.
Oh, okay.
I,
Okay, Commissioner Altman.
Aye.
And Chair votes aye. All right. Is there anything else we need to address on this one tonight?
Not unless you want to discuss anything that wasn't included on the matrix.
Sorry, what was that?
Not unless you wanted to discuss anything that was expressly included on the matrix or just general comments.
I maybe have a couple.
Sure, go ahead.
And let me know if I'm speaking inappropriate or out of turn or okay. I'm just gonna shoot from the hip here. One question I have is I think I had a client go through this and there was a vacant property, there's no home on it.
Mhm.
They wanted to build the ADU first and then the single family house, and they weren't allowed to do that. Why? I think a lot of people in that situation would go that way if they had the option. I was just curious why that law was in place that way.
That's a great question. I could probably answer it in a couple different ways.
Okay.
The first is there's not necessarily anything that would expressly prohibit someone from doing that, provided that the original dwelling that they built met all of the standards to be converted into an ADU at some point in the future. So let's say you built a 900 square foot dwelling, you meet all these potential rules that might be put in place here in Deschutes County. And then a couple of years later, you say, now I want to build a primary dwelling and convert that. I think this program would still allow for
Okay.
that, as long as you had enough foresight to build that initial dwelling to those standards. Another thing that's come up that's a slight tweak that wasn't included that we wanted to clarify from the previous set of draft amendments that the commission reviewed is we actually tweaked the language to ensure that somebody that wanted to build a primary dwelling and an ADU simultaneously would be able to do so without running into any kind of hiccups. One of the requirements from Senate Bill 391 is that you have to have an existing dwelling on site in order to build an ADU, but they don't really make any indication of how you would deal with those situations like simultaneous development, or if you wanted to convert a pre-existing dwelling. But we think that we've crafted it in such a way to deal with those kind of nuances and allow maximum flexibility.
You would call that
Conversion.
smaller home your primary at first, and then you would convert it
Exactly.
later. And there's a process to doing that.
So is that something that would be allowed in existing code, or is that something that we as a commission, should we choose to make that recommendation, forward that to the board to suggest that that might be an alternative to build a small unit and then later convert it to the ADU?
That's something that would be allowed under the current.
You
version.
can just
Okay.
do that now, as long as you meet.
As long as it meets the criteria.
Things that meets the standards. And again, you had the foresight to build it to meet those standards ahead of time. There shouldn't be any potential
Okay.
issues.
Okay, thank you. Okay, I have another question. Let's pretend I had a shared well with 3 users. And one of the users was going to add an ADU. Could I, as a shared well member, oppose that? Or how does that look?
That
Good
that
question.
would likely be a question for the Water Resources Department, probably not for us. The
Okay.
only thing that
In your well agreement.
correct.
well.
Yeah.
Mhm.
So that's again, water rights under almost all circumstances fall outside of the realm of land use. And so we as planning, I mean, we could tell you who to talk to, and we did include some specific language in here again to go back to that. For the purposes of Senate Bill 391, you only get the one exempt use, even though you're building a second
Mhm.
dwelling unit. And
I
so
think once you get past 3 units, you become a community water system.
potentially, yeah, that's but ultimately,
Yeah.
You already have
But
your
it would
3.
still be 3 shares.
Not when you have an extra dwelling,
The extra dwelling would be a 4th, and then you would need it.
because that's a whole nother household.
So if you had
I thought we were
2
just talking
already-
about one set of well exemptions.
Right.
That's what I'm just,
Yeah.
that's what I was getting at,
I-
is exemptions. You don't have additional
There's still
exemptions.
exemption, but I don't know. That's back to the Oregon Health Authority and all that, and a whole of folks we don't deal with, but
primarily you'd be dealing with OWRD and other parties, third parties that are outside of land use and planning. And
my guess is if you're on a shared well, you're gonna have to get permission from the other participants.
yeah, and there's some specific language that says you have to comply with all water law associated with any type of residential use that's built into 391 as well.
Anybody else? That answer all your questions? Anyone else? All right, thank you. Oh, actually, what I would suggest is that we have a motion to adopt the full slate of our recommendations, since we didn't vote on most of them.
That, and that's what is just, how do we word this? So I move that we adopt the recommendations as discussed for the Board of Commissioners
Yeah, as approved.
as approved.
Yeah. Is there a second? Okay.
I'll
All
second.
right, it's been moved and seconded. Would you like to discuss it?
I think we did a great discussion on all the items, and we shall move forward.
Perfect. Any other discussion? If not, Commissioner Trowbridge,
Good.
are you voting?
Oh, sure, yes.
We're
Hey, Commissioner Williams,
aye.
Commissioner Kelly, Commissioner Altman,
Aye.
and I vote aye. All right. So next on the agenda. I have nothing else on the agenda. Comments? Staff comments?
Commissioners, Commissioner Cyrus for being the chair today. Thank you. Excellent facilitation. I don't have any specific items. I likely will at your next meeting, but again, want to welcome our 2 commissioners, Commissioner Trowbridge and Kelsey, and to our 3 members who are quite seasoned to help accommodate this transition. We're really excited to have the full commission and appreciate the time that the two new commissioners spent with me and my staff this afternoon. So thank you and welcome. And I'd like to say it's going to get easier, but it just depends on the agenda and the topics. But I think this was an excellent meeting to kind of assimilate you into the commission, into our processes. So great to have you on board.
Will?
Yeah, good evening again, commissioners. Just some things that have been moving around in the building and with the board. I think we've talked a little bit about Senate Bill 1013. That's a permit. That's something that's come out of the current legislative session that allows counties to consider adopting regulations to place RVs as effectively a second dwelling unit on certain residential properties. It comes with some significant sideboards. They have to have full hookups. They can't be VRBO'd. The property has to be owner occupied. And we recently went back to the board and asked them for priorities about how to allocate staff time following the conclusion of the mule deer process. And they selected that for our current efforts. So that's something that you'll be hearing more about as we move into the future. Just wanted to give you a little preview before Tanya Salzman is working at that, and she'll be presenting more in the future about it. Something that we also had presented to the board was House Bill 3197. I know that we talked about this at some length, and for our new commissioners, this is a bogglingly complicated topic. So we should talk some other time at some depth, or you should review prior meetings where we've talked about it. But there's a requirement in Oregon Revised Statute ORS 197-307 sub 4 that required cities to have clear and objective standards for the approval of housing. There was a concern that discretionary standards were leading to complicated and needless appeals of the housing that's so vitally needed in Oregon, and that there was a preference to allow to provide a clear pathway to developers so that they could know that if they followed certain rules, they would walk away with a housing development rather than a bunch of appeals. In 2017, there were changes to language, and in 2017, that provision was, many believe, accidentally applied to the entirety of the state rather than just urban areas. And there was cases from the Land Use Board of Appeals that came out of Washington County addressing that issue and finding that, yes, in fact, that does apply everywhere. This was, of course, concerning to planning, because the effect of a provision is if you have a provision that doesn't have a clear and objective pathway, it's effectively stricken. So if you said, your house is allowed provided that the fire department is happy, that's not clear and objective. And so at that moment, there are in fact no fire standards, which is obviously not an ideal outcome in most circumstances. House Bill 3197 was brought up to patch this, and it did it in a particular way. It removed the provision for clear and objective standards from resource zones. It allocated them to specific residential areas, and it gave counties 2 years to presumably fix their code so that these clear and objective standards exist. To our at least initial impression, that's going to be a multi-year, multi-phase project to go through our code. The city of Bend has struggled with this, something, for example, in their subdivision code, that they have a requirement that the sewer line in a subdivision be close to certain other features. And the courts concluded that close was not a clear and objective standard, and thus was stricken. And so I think there's a lot of work to be done in there. The board had prioritized Senate Bill 1013, the RV bill, over that effort to patch the code in that way. But the Department of Land Conservation and Development has made some grant dollars available for application, and staff has come back to the board and asked them if there were grant dollars and a consultant, would you be interested in seeing staff pursue grant dollars and a consultant to work on this? And they said yes. So we are, through the course of this month, working towards applying for grant dollars to get some resources to make those what look like significant changes in our code. This is a thing that's very much in play. From the latest discussions we've heard, this issue may be revisited either in a summer session if one occurs, or the short session in 2024 at the legislature. So lots of moving pieces, something that's a big deal, and just wanted to keep you generally up to date on that. Finally, kind of calendar updates, certainly here coming up on July 24th. Let's see, oops, on the wrong page here. So coming back to you next on July 27th, we've got the Tumaloda Community Plan Update Work Session and a comprehensive plan update and document review with Nicole. On August 10th, the Transportation System Plan amendments, there'll be a public hearing scheduled on that day, as well as Tumalo Community Plan updates. And we've got deliberation placeholders for the Tumalo for the Transportation System Plan on August 24th, as well as the Tumalo Community Plan. So some things that you've been working on over time coming forward that we've kept you appraised of, and now are ready for the hearings and hopefully deliberations. So you'll see I've been sending out to you every Friday a status update of what's coming up. If you have any questions about where those are at or concerns, I'd love to hear it.
So the transportation system plan, could you send me another copy of I'm starting to get a whole lot of comments directed to my email from Black Butte Ranch. Yeah, and I mean, just for your information, I have offered to meet with any of those folks that are concerned about it and hear their concerns, and I encourage them to participate in the public process.
Thank you. And that's all I have for you this evening.
Okay, Kyle?
Don't have anything.
Stephanie?
I don't have anything, but thanks for having me here tonight. And it's so great to meet the two new commissioners. I'm looking forward to, continuing to help out where I can. And you've got some big things coming up.
We always appreciate having you here.
Yeah. You
Keep
bet.
us out of trouble, hopefully.
I don't know about that, but.
So, any other staff comments? Okay, Commissioner Trowbridge, any comments?
No comments.
Mr. Williams?
So the two of you bit off quite a bit today. I know my very first meeting did not have a matrix in it and did not have to make a lot of decisions. So good job just stepping in and getting it done. Kyle, excellent presentation tonight. I don't look at the matrices enough to remember like, okay, this is original, this is what we decided, and this is what we might be doing. But I really do think it is the best way to work through these decisions and recommendations. It just allows us to be a little more concise about it. And sitting chair Cyrus, thank you very much.
Oh, thank you. Commissioner Kelly?
No, I just want to thank everyone for making me feel very welcomed and prepared. I think I'm excited to refine my process of research and education prior to meetings. So thank you.
Commissioner Altman?
Thanks, Chair. Thank you for running an efficient meeting tonight. Very, very good. And welcome to the two new commissioners. I look forward to meeting you in person. And thanks, as always, to staff for your incredible depth of knowledge and your great presentations.
Okay, and I would also second all the comments and thank everybody for making tonight go smoothly, and welcome to the new commissioners. And I did have one thing I wanted to bring up with regard to a comment that was made earlier regarding in our orientation about the opportunity to do panel discussions in areas that we would like more information and actually potentially take another look at. You know, we've spent the last, not I, but you guys have spent the last almost 3 years dealing with the mule deer issue. And granted, the Board of Commissioners decided not to move forward with overlays, but the significant amount of information that came out in the hearings process, I think we just barely touched the tip of the iceberg with regard to maybe addressing some of the possibilities for some actual solutions. And I would throw out to the rest of the Planning Commission of whether there might be a potential to convene a panel discussion that maybe includes some stakeholders. I know we sent a recommendation to the Board of Commissioners, and sounds like they have maybe passed on creating a formal stakeholder group, but I still think there's a solution to be had if we could get everybody together, maybe in the same room. I guess I would love to see ODFW, the Hunters Association, the Forest Service, BLM. I mean, trails folks, some landowners, everybody in the same room with a panel discussion on, okay, guys, who accepts what parts of the responsibility and how can we actually come up to us with a solution rather than try to throw it all on the backs of, landowners, as has been rejected. But I'd just throw that out for thoughts. I would certainly love to see something like that happen.
You want to speak to the Oregon Department of Fish and Wildlife process?
Yeah, for sure. So, of course, as we came to the board to discuss the mule deer process, this question of a stakeholder group came up, and they had some hesitation about that. And I think one of the drivers there is that there's a concurrent process going on right now through the Oregon Department of Fish and Wildlife, where they're doing a region-wide update of their mule deer plan. And so that has a variety of elements associated with it, including predation, habitat fragmentation, disease, poaching. And in our discussions with them, they're focusing on that at the moment. We've reached out to them to see if they'd be interested in coming. The board said that they would be interested in having ODF&W come to present to them. And they've said, we're really in the middle of something, the relationship's valuable, but, we're working through this process at this point. And so to the extent that people have concerns about those issues, that right now they are receiving comment and integrating those into the plan. I can definitely let them know that the Planning Commission has interest in that type of coordination and outreach, and give you some feedback about their availability for that.
Okay, I say just on a personal note, the research I did indicated that maybe ODFW is kind of punted to someone else as far as the blame without accepting, the criteria that they've exceeded with their cougar plan. So like I say, there's other players with regard to trails and everything else. And that was all maybe they're addressing it, but, and maybe they would be willing to come and tell us where they're at. And maybe we don't need to take a look at it anymore.
I know that the Board of County Commissioners respectfully asked ODF&W to come and discuss this mule deer wildlife management plan, which hasn't been updated in 20 years. So when those dates become available and they're finalized, we'll certainly let the Planning Commission know of that meeting. And then it may work, the ODF&W sounds like they're maxed out at the moment, trying to fulfill all their responsibilities, plus update this management plan. The management plan on the website, the deadline for that completion is, I want to say, early in 2024. And so it may, the planning, as we are aware of the Planning Commission's summer fall schedule, the timing may work out if it is done in the winter of 2024, asking ODF&W to come and share the results. And then that could inform maybe a panel or whatnot. So we are certainly open to engaging in a panel and allowing for discourse. I just recognize that your late summer and fall schedule is filling up on committed projects. But certainly there could be opportunities as we get into the next calendar.
Okay, well, let's, like I say, if there's interest from the other commissioners, let's keep it in mind.
I actually attended the last Board of Commissioner meeting and made statement that I would like to see a stakeholder group put together.
Perfect, thank you. And that's all I have. If anybody else has any comments.
Good job in the back.
Oh, yeah. Thank you.
Awesome.
With that, meeting's adjourned.
So